my Lord's permission, may I mention? Because this is an IA in a original suit, Malas. We have moved for release of Malas about 1,000+ crores from the union. I'm for the state of Punjab, Malas. And Malas, there is some urgency in the matter. We had moved the email 2 days back. The registry indicated that in due course, the main suit will come. Malas, that's all right. We are requesting only the IA may be listed if next week, if possible, Malas.
Of September.
Malas, that will, Malas, because there is some urgent need for funds, Malas. So if in August, if it's possible, Malas, we'll be extremely grateful. I'm so grateful.
One request, Manoj, which I may not be able to make in a mail. The matter is listed at item 5 today, not likely to be taken up.
Tola will.
Because of that, Manoj. Look, this pertains to child marriage. Look, there are different views taken by different high courts and views whether child marriage is permitted or not. In one religion, another religion, we are arguing on constitutional principles. But if that can be listed on priority on any Wednesday or Thursday, all matters, my lord, consensus.
But we will.
No, not today.
Yeah.
Next Wednesday, Thursday, or any immediate Wednesday, Thursday, my lord, because new judgments are coming and we are multiplying SLPs.
We will ultimately settle the matter one.
That's all.
With my lord's kind few minutes.
My lords, I'm mentioning in item number 6. My lords, I'm mentioning in item number 16. My lords.
Ma'am, 1 second. 1 second.
Item 2, 13, 17 and 18 are West Bengal matters, where not likely to be taken up today, so some date may be indicated. But we have filed 8 compilations. That part is complete. LOD has also been filed.
With my lord's kind leave minutes. Uttar Pradesh.
There is only one problem that fresh petitions are being filed regularly, so whether we can include that or we just leave it at that.
Lordships, the West Bengal matter which my learned friend is mentioning.
West Bengal matters, we will re-notify them on a particular day.
Your
So
Lordships,
that then we can conclude them in about a day or day and a half.
we'll need 2 days for that, Your Lordships, because it's
Once it's
Wednesday and
the end of
Thursday.
the matter.
Yes.
The request is not if possible, Lord, just may accommodate me next week, not week thereafter.
And next week, we also have other matters which are listed, so we'll keep it a little beyond.
With my lord's
May
kind.
I- Your Lordships, may I suggest
1
after
second.
the
First
15th?
West Bengal, then other matters, so that the West Bengal lawyers can all.
Lordship, item 2. Whatever the.
Crowd will disappear.
On that day.
We'll keep it first on board on that day. So that then we'll start with-
May I suggest,
Keep
Your
them,
Lordships,
keep them,
need
keep
2
them.
days?
If Lordship kindly,
It's a fresh notice to be issued.
there are.
West Bengal.
Yes.
Now, if we start issuing notices on all matters, you're all here.
Yes.
Wherever there are notices, replies have been filed, we'll hear. Others, council may supplement and we'll.
Lordship may just tag this matter.
As long as the matters are listed,
All
Lordship,
other
we don't
people
have an
will
issue.
simply tag. You're all here. Make sure that copies are served on the respondents, that's all.
Lordships, listed on 21st and 22nd, because after the Independence Day vacation, Your Lordships will have Wednesday and Thursday as a block, Your Lordships, because this matter will take that much time.
Okay, I'll just look at what the
Very
the
well.
matters are.
Minutes with.
Great.
First on board.
2 days it will be.
Mr. Gupta is stating us about the Civil Service Commission. He has some difficulty in the first week of September.
All right.
Minutes
And we
with you,
give
Lord.
some space, my lord, so that we can be ready.
By lunch or maybe by 4 o'clock.
Anyway, your lordship's convenience.
The reason why I'm not announcing a date right away is I want to see what are the other matters listed on those dates, so that then we know that this is a clear date.
Lordship.
Minutes with you.
Could you just tell me?
That we can internally do that.
They are new matters.
Talk to the nodal council. They'll make sure that the 2 young juniors will make sure that all.
Asta, you can speak to Asta.
And one more thing, authorities, Asta, make sure that authorities are all in one compilation. Otherwise, what we find is authorities of one lawyer in their compilation, another lawyer's
Lordship, we
compilation.
have created 8.
There's a common compilation has been filed.
Common compilation.
We have filed a common compilation.
So otherwise, in Tola, this is a problem which we are having. You have to constantly switch between different lawyers' compilation.
Yeah, Lordships, they've done a good job. They've put the statutes in one volume, they've put orders in another. It's
Minutes with you.
well done.
There is a common compilation. We have filed 8 volumes of common compilation, so there's no special.
Your Lordships, may I mention one more matter? This is that vulnerable witness matter. It was to come up yesterday, Your Lordships, and the Commission's mandate was till 31st of July. It may not need any listing, Your Lordships.
All right.
Which will
It
not,
may not
which
need
will,
any
Grateful.
listing.
Yeah, it is on the list. It will not be deleted. We have to formally extend the remit of the commission.
Yes, Your Lordships.
Which Your
So that's
Lordships-
6 more months are
which,
needed to.
which your Lordships kindly millets.
Great.
Uttar Pradesh service track. Mails were sent twice, and last week it was mentioned they're superannuating millets.
Age of retirement has been reduced. How can we grant interim order? Like,
No minutes.
other-
Think this
retired. I mean, what do you do? These are part of service.
millets, it's been arbitrarily reduced, and they have to demit the office millets.
We will hear the matter.
It's virtually come to 1.5 years from 5 years.
May I mention? We hear the matter.
Any other, we have sent the mail also, millets, any date as my Lordships could have it.
But would you, would,
All right, West Bengal now completely over. Yes. The lawyers from West Bengal, the West Bengal matters now from MPs.
But in West Bengal matter, my lord,
Just 2 or 3 days.
All right. Noted, Kalvi. The time for filing the written submission on the West Bengal group of matters is extended until next Monday.
Lordship has not issued notice consciously in matters which are related to existed candidate. So, Lordship, we are.
Absolutely, I remember that.
Yes.
We therefore, waitlisted candidates, we have only tagged those matters that.
Directly affected.
Yes.
Millets, if I'm forgiven, not to be deleted, but UP matter, not to be deleted.
Lords, there is a fresh matter today. Would your Lordships be taking up, or my lord,
What's the matter?
item 3, my lord, it's a taxation matter.
I appear in 3 minutes.
Can we keep that on Friday? So that
Friday, Monday, my lord.
3 will not take long, my lord.
Monday, my lord.
we want to start Tola actually because we are in the midst of that.
It might take some time, not on my side.
Letter notice would have to be issued because there are 2 assessment years in which the coordinate bench of the High Court has already granted stay. So we
My
are.
lord, we'll assist your Lordships either Friday or preferably Monday.
Friday or Monday we'll take it.
Well, it's either day. Either day is
Take it
fine.
up on Monday. So
Very
he was asking for
Well,
Monday.
it's- will they accept notice because this has to be, well, there
No,
are,
no, my lord, I'm here, my lord. Why notice? I'm on caveat. my lord.
He's here.
there's 2 identical
But
matters.
you will just take it up on Monday.
Very
So-
well.
My lord, item eight-
Right.
But I am
item
troubling my lord
eight
once
is-
again.
My lord,
West
item
Bengal
8
matter.
pertains to the product by process, which is a judgment on that issue, which was the first of its kind in the country. All that you are requesting on any Tuesday, if your lordships could consider taking up that, it's an important issue, my lords.
We will
Item
do
8,
that.
product by process.
Today may be difficult.
No, no, my lords, today I know your lordships are the whole day going to be occupied with this.
May I, my lord,
You know,
may I have my lord's kind leave, my lord? Again, my lord, to trouble the ship with West.
My lords, in
give dates right away in the afternoon.
4 and 7.
My lords, in 7.1 is the Sharad Pawar one, 7 is the Shiv Sena one.
Yes,
Now, my lords, no, all I'm saying is on 29th of July, your lordships in the NCB matter said 4 weeks returnable notice. So just please keep that in mind on 29th of July, your lordships.
Not really dependent on the
Please,
other.
my lords.
The Shiv Sena, the papers are all complete.
Right.
NCP, the papers are
Only reason I'm saying is because they're tagged along, there's a returnable notice of 4 weeks in that. Submissions have not been filed, the lordship normally appoints.
That will be done before the date, well, the idea is it will be done before the next date. You're not hearing it today.
Not yet been done, my lord.
all right. Should we
Please direct
do
that, please
right
direct
now?
that. Yes, please direct that.
So
Because your lordship is giving a date, prior to the date, we'll complete all this.
So how much time? Say about
Plus,
in the NCP matter, how much time will you take?
2 weeks,
to get the
plus,
compile?
My lords, we'll need 3 weeks to file our reply in that, my lords.
very well, 3 weeks, call it in September, Melissa, early
All
September.
right, we keep it.
Give an actual
we
date.
said 3 weeks. The NCP matter.
Yes.
Which is 7.1.
That's right. 7 and 7.1.
Right.
Shortest date for
Neeraj
both
Krishnan
required.
Paul,
Melissa.
then on the request of Mr. Neeraj Krishnan Paul and Senior Counsel, time to file a counter is granted till, give them exactly 3 weeks to file a counter. In the meantime, who are the 2 nodal counsel? Tell us that.
Lordship, just say no, they're already there.
Chirag.
Council will be Mr. Chirag Shah in the Shiv Sena matter for us.
And Abhikal Pratap Singh in the.
All right, just give it in.
I don't
Give it-
name-
give it
to the court master.
Nodal counsel. and then the usual order for preparing a common compilation of documents. This should be done within a period of 2 weeks.
2 weeks, I'm obliged.
Well, may I trouble ask you once
Submission can
again?
also be forwarded to the nodal council within the said period.
West Bengal matter is one difficulty. May I
12.
protect your lordship?
11 and 12, both relate to physically challenged people. One is engaged on prosthetics, that's item 11. And item 12 is on selection of blind and physically challenged people in the IPS. We want to say at least in non-combat posts, they can be accommodated. They are saying they can't be, whereas in CR, it's a short term, we have missed 3 rounds of selection, we have missed because of the pendency. The government is saying IPS, we will not select anybody who is physically challenged. But we have said there are a number of non-combat posts.
That will, this will have to
That
be
can be
heard.
kept next Tuesday as.
I'll give you a date in time.
May I mention an matter, my lord, in which the order is uploaded yesterday, my lord, in which there is a small typographical error. That
Our order, whose
yes,
order?
my lord, the same bench order, my lord.
Give us the order.
Date is not properly mentioned, my lord. That date may be changed. That's all, my lord. The date of the impugn, para 3, my lord.
Given notice.
Yes, my lord, we have given the letter also. We have informed the other side. Para 3, my lord, may see kindly. We request the NCLT to complete the exercise by 31st August 2024. The NCLT shall dispose of the application on its own merits, uninfluenced by any observation made in the order dated, it's written 25th August 2023, whereas it should be, my lord, 5th October 2023. That is the impugned order, which your lordship had mentioned. So there is no order called 25th August 2023.
This date was mentioned, that's why we put it as.
No, my lord, the impugned order is 5th October, my lord. That's
Who's
somehow.
for the other side? Who's for the other side?
We have informed the other side, my lord. They are also. Which matter?
Well, this is like one.
Order, my lord. That's why your lordship said that.
Only thing is that we wish the other side was here because if it, then.
We have informed the other side, my lord.
There's little change in the order can make a very critical difference. Just get Mr. Sai Kumar at lunch. Or get him by 1 o'clock.
Okay, bye. Okay,
Let it be passed in their presence, that there is no.
Sure, my lord.
My lord,
Deeply obliged.
could I please, my lord, mention a matter?
The date I don't recall.
There is a slight issue.
My lord.
Item 4, your lordship has dealt with, 2 and 4 your lordship dealt with. In 7, there are 2 matters. We are not seeking any time. Your lordship can't hear it today. Your lordship had said yesterday, 7 your lordship will take up very quickly. 7.1, these 2 weeks of.
No, that's seven, the compilations are yet filed, my lord.
Said indicated on 7th.
Listen, 7, when are the compilations going to be filed?
My lord, everything is ready in 7. We file it today, my lord. Your lordship said indicated that it will be taken up tomorrow.
That's a common compilation. How can my learned friend without consulting?
1 second. When is the common compilation going to be filed? Because we don't want to go on with the matter unless you file.
That's right, my lord. That's
Even on mentioning, people argue so much.
No, the compilation is not filed. It's a
Who are the nodal council?
not yet the
That
point.
is not
Your
happened.
lordship, second, who are the nodal council?
No, that has not happened.
Don't answer my question. Who are the nodal council?
That's not yet indicated.
In 7, we have not indicated.
No, my lord.
But
But
we-
it was directly to be
I
listed.
just said that, you give the 2.
That
names
is
to the-
today indicated for the first time.
Yeah. So therefore, the compilations have to be prepared in 7.
My lord, we are ready to go on with it. My lord, we can do it within
You are
2
ready
days.
to go on with it right now, but we have to have one common compilation. You don't have to write the
We can
judgment
do
at
it
the
within
end.
1 day, my lord. We can do it
You
by
don't know what happens when you have 20 lawyers arguing matters and you have to deliver a judgment at the end of arguments. You don't know where to look for material. Therefore, we want one common compilation. We just said 2 minutes ago that let there be 2 nodal council.
Correct.
They mentioned the names of 2 council. We said give a slip to the court master so that we can then have them prepare a common compilation. We have given 2 weeks time to prepare that
2
common
weeks would be
compilation.
too long, my lord, because the elections are due within a month. All I'm requesting is we can do that exercise within 2 days. There's no difficulty. We'll do that
We have
exercise.
no problem. You tell us when will the.
Kindly have it next week, my lord.
Next week.
Kindly have it next
All
week.
right, common compilations will be prepared by the council, should we say within a period of 1 week from
Yes,
today?
yes.
We can do it within 3 days, my lord, by end of this week.
You can't dictate to the court what's the time.
I'm only requesting, my lord, we can do it by Friday. Kindly have it on
my
next
lord,
week.
Who are the council?
Kindly make
So there are-
Mr. Sharma from our side.
Right.
He's been formally notified yet.
Right.
And Mr.
Chirag Shah.
We have 40 respondents, my lord. On our side.
Should not be.
But it should be for 2 weeks, at least the convenience
One nodal
compilation.
council, you prepare your common compilation within a period of 1 week.
But 1
Let
week
it
may
be
be a little
2 weeks,
difficult,
my
but 2
lord.
weeks.
Let it be 2 weeks.
This kind of
No,
election
that-
there, Manoj. They have to make a common compiled paper.
All right, instead of making the common compilation by Tuesday next, we'll give you time until Thursday next. So you get 10 days. We give you 2 more days. You
All right.
prepare the common compilation by Thursday. That should be good enough.
With your permission.
And my lord, 7.1, the timeline will be 3 weeks of reply in 7 point.
First matter you've already.
7.1, my.
I know.
My lord, kindly have it immediately thereafter, my lord, after
Why don't you come and sit here
I'm
and
so-
tell the court master what dates you want? Ultimately, you see this is too much. You've seen the kind of pressure of work on the court's time. If you'd like to come and sit here, please come and sit here and sit for a day. I assure you will run for your life.
My lord, we see that every day, my lord. I'm sorry, but my lord, I'm only requesting if it's
Give
convenient.
us the convenient date possible.
That's right. We'll give the date after 2 weeks.
Item 4, both of us appeal lordships. Sir, notice has not been issued. Can it come on 12th? It's an admission matter.
Friday.
Fourth, item 4 should have
Well,
come
as-
on.
This is actually for final disposal. Your lordship said, hold your hands for both sides.
Yeah, we're holding hands.
That matters. So therefore, it's really ready for
Why
the
should there
argument.
be notice in item
There
4?
are
You're all
pleadings
here.
and counters and rejoinders.
Now everything is ready.
Yes.
So it has to be heard. That's all.
No counter, nothing. Just your lordship said we'll take it up straight away. So this pledging of securities.
Right. That's the Edelweiss matter.
Yes.
Yes.
So it'll be on Tuesday only.
On Monday. All right. Yeah, we'll keep.
No. I thought if it was Monday.
Today we take it up.
All right.
We have, unless we finish
Your
the group
lordship-
of 700 matters, we can't make any progress in anything else in our board. And now that.
My lord,
I-
my
I-
lord,
I-
commission
sometimes
mentioned
mention
the matter.
that-
I'm seeking relief against demolition of a subject structure. It's the sole source of storage of water
When was
and
the
supply.
order passed?
30th of July. We filed, there's a diary number. It's a fresh matter, my lord.
Just send an email. I'll have it listed immediately.
Obliged.
Lordship, sir, with your permission, Lordship,
Item
there's
10.
extreme urgency in my matter.
The jet matter, item 10. But
Yes,
I think your lordships are
We have
busy.
said that we are listing.
No, I know it's today. It's on the list today. I'm just saying because your lordships are busy. Your lordships are
It
busy.
will most probably be, it'll be, I've given dates for those matters which we can't take up today. It will
Right.
probably be 30.
Very good. Very good.
Your Lordships, with your permission, your Lordship, there's extreme urgency here.
Graduate admission to AIMS. Lordship can have it day after tomorrow because Friday is the last day of counseling. So it can be had day after, my lord. Thursday, my lord. Thursday.
My lord, may I just mention item number 2, my lord, 2 days listed. It's a West Bengal matter, my lord. I was in the waiting list.
Is over, sorry.
No, my lord, that is what I'm saying.
Sorry, I'm not hearing you. I'm in charge of my phone. I'll not hear you now. West Bengal is over.
Sir, I'm seeking a clarification, my lord.
I'll have to evict you from the
My
court.
lord, deeply.
I have only one
Lordship.
request for the West Bengal matter. Compilation is it
No,
complete?
sorry, West Bengal is over now.
Only,
Anybody who tries to argue West Bengal will be evicted.
no, I'm not arguing that way. Only
No, please.
the
West Bengal-
compilation is that complete.
Lordship, just
Sorry,
Lord-
West Bengal, no further mentioning. We have done what we had to. Everybody was there when we passed the order.
No, I have been
No
shouting
further.
that Lordship
Sorry,
asked me
nothing.
to wait. I have been waiting.
Nothing in West Bengal. You argue it when it reaches that.
Okay,
day.
wait. Keep it.
Lordship,
Because I'm
this is
mixing item
urgent. I'm
16.
really sorry. My lord, I have filed an SLP impugning the
12 p.m.
Bombay High Court decision with respect to wearing the niqabs, hijab in colleges. I have filed this. It's just that,
I know it's coming up. It's being listed. I've already given a date for that matter.
well, this is the Bombay High Court one.
That's right.
we have
So
our
you told me the matter. I remember because
Oh, very
you told me in the evening that these are the facts.
Yes, my lord.
I've already directed it to be listed.
Very well. My lord,
I've given a date.
day after, actually, my lords, our unit test, which is our internal exams, are starting. So,
Yes.
may
My lord, I'm in item
16 Milords. Milords may hear item 16 Milords.
My lord,
If my
my lord, I'm in item 15. It
Lords,
is
if item number
listed on the
16
top of the,
Milords.
will it be taken up?
Today, no. I don't think because this matter in hand will take us through the day, I think.
My lord, it is urgent because I have already been convicted of contempt and the tomorrow is the matter in Himachal High Court.
That is that Himachal.
Yes, my lord.
All right, before we rise for the day, we'll take it up. Give you a little. Let the West Bengal Tola matter get over and then we'll take this.
Lord, it's
50
just-
will retain.
Milords, I'm mentioning in
Take
item
just 2
16
minutes, I'll
Milords.
explain it.
Nothing takes 2 minutes, sir. We also know that. Nothing takes 2 minutes, but we have a matter in hand. We'll take that and then we'll take up this matter.
Milords, I'm mentioning in item 16 Milords. Telangana judiciary candidates have to submit documents till 12 p.m. Milords. They have to post it by 12 p.m. Milords. And they can physically submit till 5 p.m. Milords. Today only, Milords. If Milords may hear the matter, Milords, there's an urgency in this matter. They can't post it after 12 p.m. Milords. Candidates live far away.
Number?
It-
Other orders in.
You are at serial number 16.
16.
Yes, my lords.
We'll issue a notice returnable on. In the meantime, the petitioners are permitted to participate in the recruitment process initiated by the High Court by its notification dated
410, my lords. 10-4, my lords. 10 April 2024, my lords.
10 April 2024, subject to such further orders as may be passed in these proceedings. Full stop. There's going to be a preliminary examination, right?
No, my lords. This is for appearing in mains examination, my lords. They have qualified the preliminary examination.
Right. The result of the petitioner shall, however, not be declared pending further orders of this court.
Grateful, my lords. Deeply obliged, my lords.
You have already appeared for the preliminary.
Yes, my lords, we appeared for the preliminary examination, my lords. As my lords have earlier passed the orders that the candidates can appear in the preliminary examination.
Cleared the prelims.
Yes, my lords, we have cleared the prelims. All the petitioners have cleared the preliminary examination, my lords.
Okay. So now you have to appear for the mains.
Yes, my lords, mains.
But we will say that your final result will not be declared, of course.
Yes, my lords, will be subject to the outcome, my lords.
That's right.
Category 1 is 13, 14, 14, 15. Assessment years.
Yes.
Category 2 would be 16, 17, 17, 18. Lord, it's implied that if I succeed in 13, 14, 14, 15, probably this would become academic. Assuming that I fail in 13, 14, 14, 15, then additional argument for 16, 17 and 17, 18. That is category 2. And the third is a general category, where the only submission is that in case if I fail on limitation aspects in all the years, then matter must go back to the High Court for the purpose of appropriate adjudication on other issues which were raised before the respective High Courts. I have 5 detailed synopses, the detailed submissions running into 40 pages, as also a synopsis which is on PDF page 1742. Running into 18 pages.
The Himan, yours is 1.106, right?
1.106.
And the
synopsis is on 1742 PDF running page.
that will be in 1.106.
That will be in 1.106.
Additional diary is only up to 633. Which is this folder you are talking about at 1742. We have the synopsis of argument.
Lordship, that synopsis is running into 18 pages. Lordship, I'll be mostly referring to that synopsis itself.
So you are talking about that 1742, which is
that's a running page which I have in my file. Got it from the registry itself. PDF. That's PDF page. Six one three. It'll be 613, page 613 in your lordship's file. No. Six one five. Please. So therefore, two categories, 13, 14, 14, 15, category 1.
Yes.
And 16, 17, 17, 18, category 2. Lordships, my principal argument is going to be the intention of the parliament and the surrounding circumstances. For that purpose, I'll be referring to some of the documents, namely TOLA as well as the notifications, so as to point out that the interpretation which is now canvassed by the revenue, insofar as the first proviso of 149 is concerned, is running contrary to the intention expressed and implied of the parliament. And in the process, I'll also answer the two principal arguments of the revenue. One is that TOLA is a fluid act and therefore it applies to whatever specified act is in operation. And argument two is, while reading the proviso of the newly amended 149, when there is a reference to old 149 1B, we have to read the extension as if it is embedded into that. These are the two principal arguments or the contention of the revenue. In the process of my arguments, I'll deal with both of them. For the purpose of making life slightly easier, I have prepared a small chronology because I'll be giving certain dates. Lordships may not have to note down the dates. Therefore, I have noted it in a chart tabular form. I can just pass on. The sequitur to these dates is, I just want to point out that Parliament was conscious of the all surrounding circumstances and the way in which the new law has been introduced. 20th March 2020, COVID started disrupting the normal life. 31st March 2020, TOL law, that is Taxation and Other Laws Ordinance, was introduced. Also, I have referred to the pages of revenues compilation wherever it is possible, so as to make life simpler for every one of us. 29th September 2020, the TOLA received President's assent, and it extended the limitation between 20th March to 31st December up to 31st March 2021. On 1st February, Finance Bill was presented in the new scheme of reopening. I'll also make reference to new scheme in a slightly detailed manner to point out that it is not merely a cosmetic change. It's not that only the limitations have been changed. Entirely new scheme of reopening has been introduced by the parliament with different intentions. And the predominant intention was to bring certainty, because I'll be referring to Honorable the Finance Minister's speech, wherein she has very categorically said that we want to bring in certainty insofar as the reopening is concerned. And that was the predominant purpose, because when we are interpreting the new provision under 149, Lordship, the submission would be that what was the intention behind introduction of this new provision. 20th March 2021, the Finance Act 21 received President assent. 31st March 21, the first notification. Immediately thereafter, the new regime of reopening came into the statute book, namely the specified act. 27th April 2021, the second notification was issued. Thereafter, the first judgment in point in time of Allahabad High Court in the case of Ashok Kumar Agarwal came to be passed on 30th September 2021, wherein this notification was held to be ultra vires, more particularly the explanation thereof. Thereafter, again, Finance Bill 22 came to be proposed on the floor of the Parliament, and that Finance Bill amended part of the first proviso to 149 insofar as limitation vis-a-vis search-related cases were concerned. So Parliament had an opportunity even to amend at that time the first proviso if the intention was such. Finance Act 2022 received President's assent. 4th May 22, Ashish Agarwal came to be passed. Pursuant to Ashish Agarwal, instruction number 1 of 22 was issued on 11th May 2022. 7th February 23, the judgment of Kinara, which is subject matter of challenge before your lordships, came to be passed. Immediately thereafter, 22nd February 23, Allahabad High Court, Rajiv Bansal, again subject matter of the present challenge, came to be passed by the Allahabad High Court. Again, 1st February 23, Finance Bill 2023. Again, it inserted third and fourth proviso to 149, extending limitation for again search related cases. No amendment to the first proviso or the language thereof. And 31st March 23, the Finance Bill became an act. Now kindly have a look at Tola Act, only few provisions, page 362 of Revenues compilation. Page 362. Chapter 1 is a preliminary chapter. Section 2, Clause B, Specified Act includes Income Tax Act. Chapter 3, the extension section, I would call it, where various limitations have been relaxed. So chapter 2 deals with extension of limitations. But kindly mark one word, because I don't propose to read the whole thing. It has already been read. Where any time limit, kindly see chapter 2, section 3 on page 363. Where any time limit has been specified in or prescribed or notified under the specified act, which falls during the period from 20th day of March 2020 to 31st day of December 2020, or such other date after 31st day of December 2020, as the central government may by notifications specify in this behalf for the completion or compliance of such action as Clause A, issuance of notice. I'm ignoring the other extensions. Kindly see page 364, continuation of that. And where the completion or compliance of such action has not been made within such time, then the time limit for completion or compliance of such action shall, notwithstanding anything contained in the specified act, stand extended. Kindly mark the word extended to the 31st day of March 2021. Because one of the propositions which I'll be arguing, and at appropriate time I'll tie the links, is that TOLA is nothing but extension and not exclusion. The argument of the revenue is that TOLA is exclusion, and therefore we have to ignore this period which is covered by TOLA. My case is that it is nothing but extension, and therefore it will have to be appropriately interpreted. The word used is categorically extended. And it is again very apparent kindly see subsection 2 on page 365.
Yes.
Subsection 2, where any due date has been specified in or prescribed or notified under the specified act for payment of any amount towards tax or levy by whatever name called, which falls during the period from 20th day of March 2020 to 29th day of June 2020, or such other date after 29th day of June 2020, as the central government may by notification specify in this behalf, and if such amount has not been paid within such date but has been paid on or before 30th day of June 2020, or such other date after 30th day of June 2020, as the central government may by notification specify in this behalf, then notwithstanding anything contained in the specified act, the rate of it is capping of rate of interest. The rate of interest payable in any, if any, in respect of such amount for the period of delay shall not exceed 3/4% for every month or part thereof. No penalty shall be levied and no prosecution shall be sanctioned in respect of such amount of period of delay. And kindly see explanation. For the purpose of this subsection, the period of delay means the period between the due date and the date on which amount has been paid. Sir, if it is exclusion, the question of delay would not arise, because exclusion means it has to be removed from the equation. Delay can arise only if it is an extension, and so also the interest. If it is exclusion, there is no possibility of levying any interest, much less capping the interest at 0.75% a month. Chapter 3, Lordships would find, refers to amendment to Income Tax Act. What I have done is, for the convenience of all of us, I have prepared an annexure which is part of this synopsis. Lordships would find the same immediately after page 16, wherein in a tabular manner I have explained chapter 3, that where all these compliance dates have been amended by insertion of a specific clause into the Income Tax Act, not by general extension of the period of limitation, where there is a corresponding amendment into the specified act, namely the Income Tax Act. Lordships would find a table, annexure A to this, immediately after the synopsis. Section 10 into bracket 23C, first proviso clause 1, time limit for filing application by fund or trust or institution or university or other educational institution or hospital or other medical institution to PCIT, CIT for grant of approval under so-and-so, when already approved under second proviso as it stood immediately before the amendment by Finance Act 2020/TOLA. Compliance period, due date as per Finance Act 2020, due date as per TOLA 2020. So this is by way of carrying out amendment into the specified act. Admitted position is that under section 149, there is no such amendment.
Yes.
Therefore, the argument which ultimately my learned friend has abandoned, that freezing of time or going back in time or exclusion of time, in my respectful submission, is not arising, because in any case, my learned friend has already abandoned that argument. However, that argument was by way of a instruction which is issued post Ashish Agarwal by the CBDT. However, that argument is now given a go by my learned friend. Therefore, going further, kindly have a look at now what is the sequitur to this TOLA Act. TOLA received President's assent on 29th September 2020. it extended the limitation up to 31st March 2021. Parliament introduced the new act with effect from 1st April 2021 and not from 1st July 21. With a different intention, completely new scheme of act, not merely just changing the limitation. And therefore, the principal purpose of the introduction of the new act was to bring in certainty. The presumption is that when the Parliament introduces a new act, it is conscious of all the surrounding circumstances, including TOLA, which is its own creature, and therefore to argue that all the while the intention of the Parliament was to extend the limitation period by allowing the revenue to read the notification and extension of time where there is a reference to old 149 1B in my reciprocal submission is not correct interpretation. Because Parliament knew that there was a TOLA Act, there was a COVID problem, extension of limitation is granted. Those extensions are already there in force. However, despite all this, Parliament came out with a new scheme of act.
Now, when you say that it was a new scheme, it came out with a completely new act. It was not a new act, it was really an amendment.
Lordship.
But when you say that it was a new scheme, in what area, in what respects do you say that it's a new scheme completely?
There are 6 elements.
Yes, that's very important.
Yes, there are 6 elements which are new. Right from 1961, the act was.
Yes, sir.
I'm sorry.
So we'll take the first.
Lodge. The first is the removal of what? Reason to believe. Originally, under 147, I'll make a reference to the act. I have already passed on the act, etc. Lordships are aware. I'm not troubling reading the act.
Just one second.
Yes. Lordships, the first and the foremost is reason to believe is removed from 147. Originally, 147 was to the effect that if the assessing officer has reason to believe that any income chargeable to tax has escape assessment. Reason to believe always has some element of subjectivity. in order to remove that and to bring certainty, Parliament has removed this what? Reason to believe from 147.
The new act, the new provision, there's no reason to believe it.
There is that it has no reason to believe. It says that if any income has escaped assessment, chargeable to tax for any assessment year. So that is the first indication that what the Parliament wanted to bring in was certainty. Lodge. Reason to believe, as I submitted, always has an element of subjectivity. On the same set of facts, a person A might reach to a conclusion which may not be equal to conclusion reached by person B. In order to remove that, now the law says that if at any income has escape assessment for chargeable to tax for any assessment year, and therefore that escapement is also now defined based on information under the new scheme. So it is an information-driven scheme.
The latter part, you just said that the escapement is also now defined in the new provision on the basis of the of information. Where do we get that?
Lordship would find it under the new provision 148 explanation 1.
Scheme or this part of the first?
No, this is the second point. First is removal of reason to believe.
Then now, how do you formulate
this? This is information-driven reopening.
Because our interpretation of the new section 148 will not only affect this case, but this will really be a general guidance of how to interpret the new provisions. So therefore we are
undoubtedly.
So the second is that the new provision contemplates information-driven reopening.
Lodge, kindly say explanation 1 and explanation 2 to section 148. Lordships would find new section in revenues compilation.
358.
Lodge. Explanation 1. For the purpose of this section and section 148A, the information with the assessing officer which suggests that income chargeable to tax has escape assessment means, and then there are clauses which are there. Originally, there were only 2 clauses. Now the law has 5, as many as 5 clauses after the amendments by Finance Act 22 and 23.
Actually, explanation 1 has to be read with the proviso.
Not.
Because the proviso to 148 qualifies the power under 148, says that no notice shall be issued unless there is information with the assessing officer which suggests that the income chargeable to tax has escaped assessment.
Not. Correct.
So that reason to believe now seems to be substituted by the existence of information which suggests.
Lot.
And information suggestive of seems to indicate an objective test as opposed to a subjective test based on the reason to believe of the assessing officer.
Lot.
And explanation 1 says means
The categories of information. One is risk management strategy, then audit objection.
and again, it is not illustrative, but it is exhaustive.
It is exhaustive.
Explanation 1 is exhaustive.
Lot. And there is a finer, again, interpretational issue also, that whether this is just an information which is suggestive of escapement of income, or they themselves contain the escapement of income. So the question would be that whether this is the information based on which assessing officer has to reach to the conclusion that there is an escapement of income, because this is merely a suggestion, or this suggestion itself is escapement of income, because it lies before the lower courts. The issue is that whether this information itself is indicative of escapement of income, or this is just an information which is suggestive, and from that suggestive to escapement, assessing officer has to carry out individual cases.
It has to be suggestive because this is at the stage when he issues notice.
Lordship.
So when he issues a notice, it has to be suggestive, isn't it? Because 148 refers to the issuance of a notice.
Lordship. That is, in fact, the argument of the SSA is that this is a suggestion period. And finally, 147. Lordship. Therefore, this has again reference to 147 because 147 uses the word escapement of income without any suggestion. Therefore, the suggestion to escapement, there is a process now defined under 148 capital A. That is the third limb of the argument, the third distinguishing feature of the new scheme.
So how do you formulate it?
That 148A procedure is now prescribed.
For the purpose of?
For the purpose of assumption of jurisdiction. Earlier, it was by way of a Supreme Court judgment in the case of GK and drive shaft. So now it's legalized. The fundamental difference between the old scheme and the new scheme insofar as 148A is concerned is old scheme reasons used to be written first. Assumption of jurisdiction. Then as per GKN, reasons would be issued to the SSE. SSEs would file the objections and those objections would get disposed of. And at that stage, it was decided whether the assumption of jurisdiction is correct or not correct. Now, first information, 148A, show cause notice, my response, order, and then assumption of jurisdiction. Therefore, even that sequence is also now changed.
Let's just dwell on it a little bit. Can you tell us the old sequence?
Writing of reasons under 148 subsection 2.
1 second. Yes.
The writing of reasons after taking the approval. Then issuance of notice. Supply of reasons to the SSC. Objections by the SSC. And the disposal order.
This was the GK and Drive.
GK and Drive era. Yes. Now there is a introduction of 148 capital A.
Yes.
Wherein again the sequence is changed. My respectful submission is so as to bring in certainty. The sequence is changed this wise that now inquiries based on information alone under 148 capital A small a.
Inquiries based on information alone. Under section 148 A.
Capital A small a into bracket.
Just 1 second, let's go to that. All right, first you tell us how that it's changed.
Small b, that is 148 capital A, small b, the show cause notice to the SSC. (148) capital A, small c, eliciting response from the SSC. (148) A, small d, passing of the order with sanction from the specified authority. And then issuance of notice under 148.
Are you contending that under the new scheme, there is a departure even from GK and Drive shaft?
The GK and Drive shaft was post recording the reasons. So first the assumption of jurisdiction and thereafter sharing that assumption reasons with the SSC. Here, the inquiries precede the assumption of jurisdiction in as much as 148 is the end result of this process and not the beginning point of that process. So that also is in the direction of bringing in more certainty because you don't assume jurisdiction first and then justify that. That appears to be the whole idea of the parliament.
Right. Let's just see 148A for a second.
148A, not. (359)
Because before the amendment, 148A was in that sense part of judicially made law.
Lordship, it was not there in the
statute. It was not there in the statute at all.
Lordship.
But therefore, according to you, what the procedure as it was contemplated before the amendment was that you assume jurisdiction,
Lordship,
wrote reasons, took approval, issuance of notice, supply of reasons to the SSC, objections by the SSC and disposal of order.
Lordship.
This was all presaged on the assessing officer has been assumed jurisdiction.
Lordship.
Now, according to you, the assumption of jurisdiction takes place much later.
Much later.
So first stage is the inquiries based on information alone. Next, show cause notice to the SSC, eliciting response, passing of an order with sanction and issuance of a notice.
Lordship.
So the
Sequence is reverse. Yes,
The assumption of jurisdiction is when you issue a notice under 148.
Lodge.
In the GK and drive shaft regime, the assumption of jurisdiction was when you issued the notice under 148. Once you issued a notice under 148, then you had, it was like a post-decisional hearing, so to speak. I mean, not exactly that, but it was in that same line.
Besides,
you are developing this point to show that, well, this is a new scheme entirely which has been made by Parliament.
yes, that is the endeavor.
That's why we thought, I mean, though what we say will affect a large number of other cases in regard to the interpretation now.
Lodge.
Therefore, we have to be doubly careful. We are not dealing with only TOLA, but our interpretation will affect the whole gamut of reassessment under the new Act.
Now, in fact, the new scheme is introduced. There, ABCD is again removed in the proposed finance bill.
Right.
Lodge. So, idea appears to be keep us sharp so that we continue to learn.
Because 148A now seems to contemplate that before you issue a notice under 148, you must carry out these steps.
Lodge.
Right?
And that too based only on the definition of information.
Information. Very critical difference actually, which has been made by the new amendment which came in.
Lodge.
So according to you, so we have now gone to three points.
Three distinguishing features, yes.
Six elements you said, Mr.
Yes, yes. The fourth one is the integration of search related assessment with 147 and 148. Originally, right from 2003, 2003 onwards, search related assessments were carried out under section 153 capital A, capital B and capital C. There was a separate scheme for search related assessments under 153 ABC. Now they have been merged into the new 147 and 148.
Where do we find that?
Lodge. Kindly have a look at explanation 2 to 148. Page 358. Lordship should find.
Two. Brought in.
Lodge. That deeming fiction coupled with, kindly see page 360, section 149, second proviso. Describe the cutoff date.
of 31st of March 20.
31st March 2021. So any search taking place after 31st March will be governed by the new 147 provisions.
So 153A, B and C, what is the position post 1/4/2021 then?
There, whatever search is, the cutoff date is now the search. So if
31/3/2020.
up to 31st March 21, they will continue under 153 ABC. After 1st April, all searches would be now governed by the new 147 provision.
So 153A, B and C is retained on the statute book only for the purpose of searches prior to
31st March 21.
March 2021.
Lordship. Now again, there is a change in the finance bill.
That's right.
No, we are going to a new scheme altogether now. So
what is the new change now in the finance bill?
the new change is with effect from searches after 1st September 2024 would be governed now by a new block assessment scheme, where a consolidated assessment of 6 years would be framed together.
Back to the old.
So back to again the old.
Again,
1995 law.
95 law. Yes, 95 to 2003.
Absolutely same reasoning, same circle, same language.
Lordship. The 5th point would be,
yes,
of course, new limitation period. Earlier, 4 years and 6 years. And in some cases, foreign asset, etc., 16 years.
Yes.
Now 3 and 10 years. And beyond 3 years, conditions.
Value.
Threshold value, escapement of income. Not the tax.
Sorry?
It's income, gross income. That the quantum of escape assessment must be in excess of 50 lakhs so as to go beyond 3 years, along with other conditions. I'm not troubling lordships for the time being.
Yes.
And the last is deletion of explanation 2 to old 147, where dimmed escapement scenarios were enumerated. Now there is no question of dimmed escapement because everything is information driven. So deletion of explanation 2 to 147, old 147, wherein dimmed escapement was defined.
So that to a certain limited extent comes in now because of explanation 2 to 148. A deemed escape. But that's in the context of a search.
Lodge. One is more appropriate, one in the context of information.
You're right. But now that explanation 2 to 147 old
Lodge
has been
deleted. There various situations were enumerated by the statute, which would indicate that these are the cases where it will be presumed dimmed escapement.
Right.
So those are now taken away. So again, that also an indication in the direction of bringing in certainty.
So these are the six
elements wherein a new.
If you were to summarize, what is the impact of these on the tax structure? How would you? First, there was an intent on the part of Parliament to bring in certainty.
Lot. And second is take away the subjectivity. Again, it's in the same direction on the part of the authorities implementing the law.
Yes.
Kindly see Honorable FM's speech in this context because she has summarized in paragraph 153 on page 102 of Mr. Ved Jain's compilation.
Page
102. Page 103 to be precise. Paragraph 15.
Case law compilation?
No.
It's
Convenience compilation filed by my friend Mr. Jain.
We've got 148 matters, category of cases, case law compilation.
Case law compilation. Lodge.
Which para?
Paragraph 153.
Yes.
153 and 154, she has summarized the intention behind introduction of the new scheme. Therefore, if to summarize this point is that it's a completely new scheme, having new intentions. The whole principal idea appears to be to bring in certainty insofar as assumption of jurisdiction and reopening is concerned. If that is the central object, then while interpreting the new act, more particularly the proviso to 149, my submission is that interpretation which furthers this object must be preferred as against any other interpretation. I've referred to only one judgment on the issue, internal page 12 of my synopsis, KP Varghese case, 131 ITR 597. I've given the pages and paragraph number. Don't propose to read it.
Just a classical judgment.
Not, therefore I am not.
Where do we find it in your submissions?
My submissions page, internal page 12.
Yes. 20 PDF, no?
Not.
Page 220 PDF.
Great.
Yes. What next, Mr.?
Next is kindly have a look at the two notifications in questions, because after TOLA, the reliance of the revenue is that after 31st March 2021, notifications have extended up to 30th June 2021 so as to justify the issuance of notices. Kindly have a look at two notifications in question. Chips would find.
Yes.
The first notification, page 410 of revenues compilation. Kindly have a look at page 410 of revenues compilation, wherein the notification is there. Chips would find again clause A, where specified act is Income Tax Act, hereinafter referred to as Income Tax Act, and the completion of any action referred to in clause A of subsection 1 of section 3 of the act relates to passing of an order under so and so or issuance of notice under 148. Then immediately clause 1, 31st day of March shall be the end date of the period during which time limit specified in or prescribed or notified under the income tax falls for completion of such action, and 30th day of April 2021 shall be the end date to which the time limit for the completion of actions shall stand extended. Again, the word used is extended. Now, what follows is material. Kindly read the explanation. For the removal of doubt, it is hereby clarified that for the purpose of issuance of notice under 148 as per the time limit specified in 149 or sanctioned under section 151 of the Income Tax Act, under this clause, the provisions of section 148, 149 or section 151 of the Income Tax Act, as the case may be, as they stood as on 31st day of March 2021 before the commencement of Finance Act 2021 shall apply. So notification itself, A, the delegates were conscious that there is now a new amendment after 31st March 2021, and B, restricts its application to the old act.
Let's see that again.
Lodge. For the removal of doubt, it is hereby clarified that for the purpose of issuance of notice under 148 as per the time limit specified in section 149 or sanction under section 151 of the Income Tax Act, under this subclause, the provisions of section 148, section 149 and section 151 of the Income Tax Act, as the case may be, as they stood as on 31st day of March 2021 before the commencement of Finance Act 2021 shall apply. So notification itself is restricting its application to pre-amendment act. The argument is that specified act is a fluid act, colorless act. And therefore, even the notification would continue to apply post-amendment. However, I am pointing out that explanation itself is restricting its application to pre-amendment act. They could have very well, because they knew that Finance Act 2021 is there in existence. They have made certain changes. So the delegates could have easily provided that even while reading proviso to 149 under the new act, this extension shall be read. That is not done. They say that we restrict our application to old act so as to extend its operation beyond the cutoff date defined by Finance Act 21.
And perhaps if the explanation had incorporated provisions so as to incorporate or to attract the TOLA provision, that could have been challenged on the ground that it is ultra vires the parent act also. So this may be a sort of an indication by the delegate or an acknowledgement by the delegate that to do so would perhaps be ultra vires the newly amended
precisely
provisions of the parent act.
In order to run away from there, they say that we restrict ourselves to pre-amendment act. But if they are restricting to pre-amendment act, then now the argument that the specified act is a fluid act, and therefore whatever may be the state of Income Tax Act at any point in time, we apply this notification even to the new act, itself runs contrary to this. Because here they are saying that it applies only to the pre-amendment act. Substituted, so repeal by substitution.
You're talking of the original provision.
Original provision.
I thought you were talking about TOLA.
No, I'm sorry. I was talking about 149 original, because the principal argument of the revenue is that while reading first proviso to the new act, whenever there is a reference to 149 1B of the old act, you have to read that 149 1B along with TOLA. And TOLA provides for extension. Otherwise, 6 years, there is no dispute. 6 years are already over. So that extension is of a repealed act. So my argument is that can there be an extension of a repealed act, repealed by substitution? There is a new act. And that too by delegates. Kindly appreciate. Lordships would know that these are the two notifications which have extended the life of a repealed act, and now revenue wants to read it along with reference to the old act so as to extend the life of a repealed act. That is something which is, in my reciprocal submission, a parliament's function. And therefore, the delegates can't extend the life of a repealed act. It's as good as writing a new act. And I have cited 3 judgments of this honorable court, wherein this aspect is discussed, that delegates have no right to extend the life of a repealed act. It amounts to writing the new law.
Yeah.
That lordship will find on page 13 of my synopsis. 2011 8 SCC 737.
Yes.
I have given the paragraph number, paragraph 44 and 49.
Yes.
2006 12 SCC 753. Para 118. And lastly, AIR 1966. Supreme Court 1942.
1942.
Para 5. Therefore, when the argument of, let me deal with that argument of the revenue at this stage, that the principal argument, one of the principal argument is that while reading the reference to the old act under 149 1B, one has to necessarily read the extension granted by TOLA. Because under the new proviso, the limitation is not in as many as 6 years in those words. They say that anything beyond the limitation prescribed under the old act is not permissible. This is a vested right which is we have given to the SSCs, because now from 6 to 10 years, so additional 4 years can be reopened by the revenue under the new amendment scheme. Therefore, they say that those who have already gained this vested right, because their matters became time barred under the old scheme, would not again be exposed, and therefore this vested right was granted. In granting of that vested right, in the proviso, they say that instead of 6 years, they refer to the limitation as prescribed under 149 1B. And therefore, the issue, the revenue wants to now contend that 149 1B reference need always to be read with the extension granted by TOLA. Because you can't read the section in isolation. There is no express removal of the word that without, you have to read it without TOLA. Our argument is there is no express word that it has to be read with TOLA. And therefore, the question of interpretation. So my submission is that we can't read that old law with TOLA because it amounts to granting extension to a repealed act. That is a legislative function.
So your submission, therefore, is reading the old law with TOLA while construing the new section 149 1B will grant an extension to a repealed act, which is a legislative function.
And that would take me to the last part of my submission.
Yes, Mr.
That can provisions of TOLA and notification issued thereunder run contrary to the subsequent law enacted by the Parliament.
And provisions of TOLA
and notification issued thereunder run contrary to the law subsequently enacted by the Parliament. Issue number 2 would be, can TOLA and notification be interpreted in such a manner so as to give them overriding power to extend limitation for a statute yet to be enacted? Kindly see chronologically. TOLA extended limitation from 20th March 2020 right up to 31st day of March 2021. On 1st April,
this one.
I'm sorry.
Yes, TOLA extended limitation from 2320 to 31/3/21. Yes.
Logic. On 31st day of March 2021, there was only one Income Tax Act in existence, and that was the old Act. Old Act I'm making only from point of view of 147. So specified Act extended the limitations of Income Tax Act up to 31st day of March 2021. What can be extended?
Can you repeat this, please?
I'm sorry. The specified Act contemplated under TOLA means Income Tax Act prior to 31st day of March 2021.
Yes.
What can be extended is something which is expiring.
What can be extended?
So, what can be extended is something which is expiring.
Yeah.
What can expire is something which is enacted. Delegates cannot extend by way of a blanket extension that whatever law may be enacted by the Parliament, we hereby extend them.
Unless the law itself gives the power to the delegate to extend its applicability.
That extension, again, my respectful submission is that extension is something which is in present. Extension is something which is where the limitation is expiring. Here on 31st day of March, admittedly, there was no new law. Therefore, there was no limitation, much less limitation getting expiring on 31st March. So when there was no law, there was no limitation which was expiring on 31st, because both TOLA expired on 31st March, notification also came on 31st March. They say that under the specified act, we extend the limitation. Now that specified act, namely the Income Tax Act, came out with the limitation on 1st April 2021, which is a day later. Therefore, what they are trying to say is that Parliament may enact any law with any intention. We have already, by way of issuing a overpowering notification, extended those dates. Kindly appreciate the incongruity. The Parliament comes out with a limitation a day later. They want to canvass that we have already extended that date. Parliament may pass any law. Ultimately, it amounts to that, because the law which is Therefore, the day on which, that is on the 1st April 21, when the Parliament enacted the new law to bring in more certainty to avoid all this heartburning on the side of the SSs, that law was already extended. The limitation provided therein was already extended by the executives a day prior. Therefore, that would amount to giving executives power to override anything which may be enacted by the Parliament. Therefore, when we are interpreting, I'm sorry. Yes, when we are interpreting the application of the TOLA read with notification in a fluid state, in a kernel-less state, and to canvas that it applies to whatever may be the underlying specified act it is something which is running contrary to this. My respectful submission would be that the notification cannot be interpreted in such a manner so as to give them such a sweeping power. Tomorrow Parliament may come out and say that after 1st April 2021, no reopening. The revenue would say that no, we have already extended 31st March 21 deadline to 30th June. And therefore, we would continue to issue reopening because this is an additional window which is available to us. I'm just giving a gross example, but just to put across the point that they are overriding the process of law by having a blanket notification. That would take me to the last part. My learned friend made few arguments. One was this colorless and fluid state of TOLA, which I have already dealt with. More so, when we read it with the notification itself restricts its application to pre-21 amendment.
The explanation.
Yes. My learned friends, another argument was that whenever TOLA was beneficial, SSAs have adopted TOLA. Whenever it was not beneficial, they are challenging this. But then there is only one amendment in 147. In all other beneficial provisions, they have continued the way it is. Therefore, on the principle of equity, when my learned friend was arguing, he said that you are taking the beneficial part and rejecting the not beneficial part. To that, my submission is there is only one amendment under 147. And therefore, we have to respect the amendment read with intention of the Parliament. My friend relied upon the judgment of Zile Singh for the purpose of proposition that this is a repeal by substitution, and therefore, as if that old act never existed. If that is the view which is adopted, there are a large number of old proceedings which are pending. If that law never existed, and as I pointed out, that under that law, the assumption of jurisdiction was on reason to believe and not on escapement. All those matters will go because there is only reason to believe. So that, my respectful submission, that is not how one has to read the income tax provision. That's all.
Thank you, Mr. Man. Thank you.
Grateful.
Mr. Saurabh Saparkar is there.
I'm here.
Mr. Saurabh Saparkar.
I'm here, sir.
Mr. Surit, we'll hear you right after Mr. Mr. Suparkar?
Yes, sir. My lords, I have had the benefit of listening to the arguments of my learned friends.
So, Mrs. Himani, just to get back to you for a second only, you basically dealt with three categories, AY 13-14 and 14-15.
Lodge.
Then two, AY 16-17 and 17-18, where you said you have an additional argument.
Yes, I'm sorry.
And then finally, the general category. In a sentence, can you just sum up what your submissions on the three are?
I'm sorry, 16, 17, 17, 18, my argument is very limited. If I succeed on 13, 14, 14, 15, in any case, the issue would not arise. Yes. Assuming that I fail in 13, 14, 15, the only argument in 16, 17 and 17, 18 is that the argument of learned friend is that insofar as sanction is concerned, there are 3 years, within 3 years of a lower authority, beyond 3 years of a higher authority. They would say that 16, 17, the 3 years would get over on 31st March 2020, 17 plus 3. And 17, 18, 31st March 21. They say that by way of TOLA, this period of 3 years gets extended. Yes. It is possible only if it is excluded. Otherwise, for 16, 17, 17, 18, nothing is getting time barred. Only thing is whether within 3 years approval is required or beyond 3 years approval is required. Only if we accept that it has to be excluded, that period. I have already made good that point.
That you already made.
Yes. Therefore, it is nothing but.
It boils down to the first.
The first
is only an additional point.
Lordship.
Yes. Yeah. Thank you. Yes, Mr. Soparkar.
May it please your lordships. Well, I have had the privilege of listening to the arguments of my learned friends. So to the extent possible, I would not in any case be repeating. I would request the Honorable Court to have a look at my note which I have filed. I'll go strictly by the note. So that is written submissions filed in diary number 5284 of 24. It's a brief submission running 5284.
Yeah, we've got Associated Power Structures Private Limited written submissions, right? Yeah. Nine-page note, right?
Yes, sir. Brief note.
We've got the note, yes.
Correct. So let me start with page 1. I have given background, and in particular, on 24th March 2020, there is nationwide lockdown, resulting into Chola Ordinance on 31st of March 2020, as a result of which time got extended till 30th of June 2020. On 29th September 20, the Act was enacted, by which time was extended up to March 21, and also power was given to extend further by virtue of notification. Then there is a notification of December 20, which is not really material. There's a notification of March 21, and then there is a notification of 27th April 21. Now, the Honorable Court has been considering the effect of this notification, and in particular, the explanations in these notifications, and the argument probably is being canvassed that they are invalid and please they are required to be ignored. Now I'm respectfully submitting, and I'll immediately point out these explanations were in challenge before Honorable High Courts in the first round of litigation. Every Honorable High Court has struck down the explanations. Revenue's appeal in Ashish Agarwal does not in any way change it. Therefore, these explanations already stand struck down. Sir, please have a look at the notification of March 21, which the Honorable Court would find is on page 410 of learned ASG's paper book. The explanation on page 410, it starts page 411.
Yes.
I read, for the removal of doubts, it is hereby clarified that for the purposes of issuance of notice under section 148, as per time limit specified in section 149, or sanctioned under section 151 of the Act, under this subclause, the provisions of section 148, 149, and section 151 of the IT Act, as the case may be, as they stood as on the 31st day of March 21, before the commencement of Finance Act 2021, shall apply. So by this explanation, by a deeming fiction, notwithstanding the fact that law stood amended, the provision was made that the old law will continue to be applicable. Similar notification was issued before I go to the view taken by the Honorable High Courts. Please see the next notification of 27th April 21, page 413. And explanation below that on page 414. This is after the 2021 Act is enacted.
Notification was struck down, this part of the notification?
Yes, yes, I take the Honorable Court. Sir, by every judgment of the Honorable High Court. Sir, my friend is not audible.
The explanation was struck down.
So 25 minutes of labor of Hemani gone. You relied on explanation.
Sir, this explanation was in challenge before every Honorable High Court. Every Honorable High Court held it to be invalid.
On what rationale did they hold it invalid?
On the ground that notification cannot be contrary to statute. When the new law has stepped in by delegated legislation, you cannot say something contrary to parent legislation. If the Honorable Court would like me, I can take the Honorable Court to only one judgment of Bombay High Court, which has captured every judgment of earlier.
Under the old law. Because of the explanation, we believed that it gave the power to issue notices from April to June applying the old law.
Sir,
they said it's delegated legislation, therefore.
Sir, let me clarify what is it that I have in mind.
Yes.
Okay, let me orally make 2-minute submission so that the Honorable Court can appreciate my line of argument. Explanation goes, in Ashish Agarwal, therefore, all notices under section 148 issued between April 21 and June 21 ideally would have been quashed. The Honorable Court says we would not quash it but make it into show cause under section 148 capital A small b. Hereafter, you give information as to what is the reason why you are reopening, pass order under section 148A small d, and then have section 148 thereafter. By the time section 148 notices came to be issued in June July 22, they had run out of time for the assessment year 13, 14, 14, 15. Now, their case in the explanatory notification or circular is theory of time travel. And that is the only ground that they had pleaded before the Honorable High Courts, that notices will travel back to the date on which earlier notices were issued. That argument is expressly fallacious because notice under section 148 has to follow 148A small d order. There can't be notice under section 148 before 148 AD. 148 AD in all these cases, order is passed somewhere in July 22. So notice has to be taken after July 22. If notice is taken after July 22, they will run out of time, period. The whole submission to the Honorable Court is Ashish Agarwal makes it very clear that all legal contentions are kept open. If all legal contentions are kept open, and if Ashish Agarwal today holds the field, and if notices under section 148 are issued after March 21 for the period of June 21 for the period 13, 14 and 14, 15, they have run out of time. Therefore, from that small perspective, please see my short note. If the Honorable Court sees, after I put table on page 1, notice under section 148 under the old provisions for AY 13, 14 till 17, 18 are issued between April 21 and June 21. Insofar as respondents are concerned, it received notice for the reopening for 13, 14 on 30th of June 21. Various high courts held that such notices could not have been issued under the old provisions after amendment in the provision of the Finance Act 21. Honorable Supreme Court in Ashish Agarwal modified the High Court decisions, substituting the notices under section 148 issued between April 21 and June 21 as notices under section 148A small b under new provisions. On 11th May 22, CBDT issued instruction number 1 providing guidelines to the revenue officer after decision of Ashish Agarwal. Communications are issued on 26th May 22 by the jurisdictional AO pursuant to decision of Ashish Agarwal providing the information which suggested that income has escaped assessment, requiring SLST to show cause against proposal of assessment, reassessment, which reply would be considered before the passing of the order under section 148A small d of that and before issuance of notice under section 148 of the Act. Petitioner filed objection to the above communication on 22nd June 22. Order under section 148A D is passed on 29th July 22, rejecting objections of the petitioner. Notice under section 148 is issued on 29th July 22. Writ petition was filed over the High Court internally on the ground of limitation, absence of any ground for reopening, impermissibility of review under the guise of reassessment, no income escaping assessment, factual orders in the order of reassessment. High Court allowed writ petition only on the ground that limitation, clarifying that other grounds raised in the petition are not gone into, since subject petitions are decided only on the grounds of limitation. Now please see analysis of Ashish Agarwal. High Courts of Bombay, Delhi, Allahabad, Rajasthan, among others, held that explanation in the notifications dated 31st March 21 and 27th April 21 was bad and illegal. If the Honorable Court would like to see only one judgment which captures all earlier judgments, so please go to the paper book of my friend Mr. Wade on page number 492. Is the judgment of Honorable Bombay High Court where all earlier judgments are referred to. Sir, Honorable Court would get it, sir.
Yes, Mr. Subhadra.
Sir, please have a look at the judgment of Honorable Bombay High Court. I am taking it because it in turn captures all earlier judgments. Sir, please see the discussion begins on page, the judgment is on page number 471 of the compilation. The judgment starts, the discussion starts on page 471.
Of which compilation?
Mr. Wade's compilation in SLP civil number 10848 of 23.
Because Wade Jain's compilation.
Santosh Krishna.
Santosh Krishna, right. That's the same as where we got the finance minister's speech, I think. What page will that be?
Sir, page 452, Honorable Bombay High Court judgment begins.
Yes.
And this issue is addressed by Honorable Bombay High Court on page 471 onwards. Para 25. Two questions, therefore, which come up for our consideration are the second question, whether the explanations contained in the CBTT circular numbers 20 of 21 and 31st March 21 and 38 of 21 of 27th April 21 are legal and valid. So then from para 26, they quote from Allahabad High Court judgment. And sir, please go to page 472, bottom, para 70, last 4 lines. In absence of any specific delegation made to allow the delegate of the parliament to indefinitely extend such limitation would be to allow validity of enacted law to be defeated by purely colorable exercise of power by the delegate of parliament. So this is the view of Allahabad quoted by Bombay. So then on page 473, paragraph 27, Delhi is quoted.
Quotations go on until page 482.
Correct, sir.
Finally, para 29, they say at the outside, we made it clear to Mr. Anil Singh.
Yes, sir. But they also give a finding on page 486. From 485, they independently start giving their own reasoning. So,
yes,
all these judgments were carried before the Honorable Supreme Court in Ashish Agarwal. Please see the judgment of Ashish Agarwal from the paper book of my learned friend, where the Honorable Supreme Court has, at the very beginning, referred to every judgment which I referred to. So please see my learned ASG's paper book, page 10. Allahabad, Rajasthan, Delhi, Calcutta, Rajasthan, Madras, Bombay. In each of these judgments, Honorable High Courts had taken a view. Explanation in both the notifications is invalid, and had therefore struck it down. Obviously, therefore, Section 148 notices issued between April 21 and June 21 would fail. So please go to my note which captures this issue so that the Honorable Court can consider from the angle which I am requesting the Honorable Court to consider. Page 2, bottom. High Courts of Bombay, Delhi, Allahabad, Rajasthan has held explanation in the notification of 31st March 21 and 27th April 1 was bad and illegal. This explanation stated that the procedure to be followed.
Lunch. We'll read this after lunch. Now, who else remains? Because we have to give time to the, we have to give, just 1 second, not everybody at the same time.
Sir, I would.
Who else will remain after?
Need about 5. I would require
After
2 minutes.
Mr. Sopakar get over.
Sir,
1 second, 1 second. Mr. Surit Pathasarthi first, then.
Just 10 minutes.
About 2 minutes.
My lord, Jaina circulated a list. My lords, go by the list, man.
We'll go by the list. Yeah.
I have that.
There are some 8-9 people still left out. Some 8-9 people still left out.
I don't know how we are going to finish
Yes.
because we are now at Mr.
Well,
Soparkar.
they are touching almost the same points with great respect.
I have something else, in fact.
Muskan Thakkar, Kavita Jha, Nitin Mehta, Salil Kapoor, Manish Shah.
And 5 more people are raising hands in the screen.
Rahul Bosque, Hardik Kora.
Cut, stop, yeah.
Mr. Venkataman, you have made an understatement.
Some quoting us.
We are now going to start at serial number 5 and we go up to serial number 37 in the list.
That's too much, Malam. Somewhere
How
they have to understand.
Wrap up, you know.
Yes, yes.
We are. I think now everybody else will have to sort of wrap up. I think.
Only if there are additional points will put up.
May I submit one of there is one SLP which is infection. So.
All right, what we'll do is, Mr. Soparkar, how long will you take now?
Sir, I will take not more than 20 minutes.
He said originally 10 minutes to start. Did not mistake.
All right, we'll see after Mr. Soparkar gets over.
My lord had asked.
Everybody
May I just be granted 5 minutes?
At lunch, I think clusters of council will have to agree who will argue for them because otherwise we'll never be able to finish.
One SLP about
5 minutes, my lords.
My lord had asked me to mention this matter at 1 o'clock.
Quarter to 4 we'll hear you. Quarter to 4 we'll hear you.
Quarter to 4.
My lord had asked me to mention this matter at 1 o'clock, my lord. That other side is here. Some error in the date printing is there.
Yes.
Yes, my lord. So that
has to be corrected, right?
So it may be corrected, my lord, in the order.
In the order dated?
In the order dated 29th July 2024.
The date?
Para 3, my lord.
5:10.
Instead of 25 August 2023, it is 5 October.
The incorrect date is 25th September. Right?
Yes, 25th August is the incorrect. Correct is
be read as
5 October 2020. 5th October. Deeply obliged. Remember, deeply obliged.
Yes, Mr. Soparkar.
Lordship is this. But I was on my note, and my lord, I was taking your lordship to the judgment of Ashish Agarwal and page 2 at the bottom. The High Courts of
Before we begin, 4 o'clock today, irrespective of the number of lawyers who are left now to argue, 4 o'clock we bring an end to the arguments on this side. Tomorrow we'll give you 45 minutes to an hour and we'll conclude with that.
1 hour and 1 hour, maximum 1 hour, 1 hour, 10 minutes. What I've done.
No, don't go 1 hour and, you know.
No, I will not. Lordship knows. I normally don't.
Long-winded counsel.
I will not do that. I have what I've prepared. I'm finalizing the note. I'll file and I'll speak only on that, as I have done always my reach.
So at 4 o'clock, please don't embarrass us, because 4 o'clock we will pull the curtains down.
Correct.
And we'll close arguments.
That's right.
Yes.
Deep you.
My lord, I was on page 2 bottom. High Courts of Bombay, Delhi, Allahabad and Rajasthan had held that explanation the notification dated 31st March 21 and 27th April 21 was bad and illegal. This explanation stated that the procedure to be followed in the extended period between 1st April 21 to 30th of June 21 in issuing notices under Section 148 would be governed by old provisions of the Income Tax Act. Consequently, all notices under Section 148 that were issued between 1st April 21 and 30th of June 21 following old provisions were also struck down. Therefore, the only issue before this Honorable Court in Ashish Agarwal was whether A, striking down of the explanation, and B, the consequent striking down of the notices was valid or not. The court held that it was, into inverted comma, the respective high courts have rightly held that benefit of new provisions shall be made available even in respect of the proceedings relating to past assessment years, provided such section notice 148 notice has been issued on or after 1st April 21. We are in complete agreement with the view taken by various high courts in holding so. But if your lordship can kindly turn to the paper book number 1 filed by my learned friend ASG on page PDF page 30 para 7.
We'll just read through your note because there's a good link you have given us. So
I did, sir. Therefore, the natural corollary should have been that the finding of the High Court's holding that notices under Section 148 between 1st April and 30th June 21 under old provisions are bad and illegal should have been confirmed. This is what the Honorable Supreme Court did not allow to happen because the judgments of several High Courts would result in no assessment proceedings at all, even if the same are permissible under the Finance Act 21 and as per substituted Section 147 to 151 of the IT Act, not TOLA, Finance Act 21. This Honorable Court stated that while the notices could not be issued under the old provisions, they could have been issued under the new provisions, and that is the bona fide mistake of the revenue officers, which is condoned. This Honorable Court substituted original notices issued under Section 148 under old provision as the notices under Section 148A small b under new provisions, everything else remaining the same. The terms of modification of decision of High Courts are provided in para 10, which are unequivocal. Also crucial are the reasoning given in para 7, 8 and 9. Observation of this Honorable Court that the revenue should not be left remediless is not blanket but contextual. In the context that the revenue, if advised correctly, would not have issued notice under Section 148 under old provisions after 1st April 21, it would have followed the new provisions which are available to it after 1st April 21. Therefore, the said old Section 148 notices are converted into new Section 148A small b notices, and the procedure to be undertaken thereafter, including passing of order under Section 148A small d, followed by notice under Section 148 if deemed necessary. Validity of notice under Section 148 under old and new provision is or was regularly judicially tested on various grounds such as time barring, change of opinion, no failure to disclose, borrowed satisfaction, revenue audit information, etc. Time and again, the courts invalidate these notices on one or more of such grounds. In such circumstances, revenue could never claim it was left remediless. Validity of notice under section 148 now issued post Ashish Agarwal must be tested on the law, on the basis of law as it stands. Therefore, the observation of this honorable cannot be construed as a blanket proposition as to validate all notices issued after 30th June 21 merely because earlier notices were issued between 1st April 21 to 30th of June 21. Earlier notices have ceased to exist in law, having been substituted to notice under section 148A(b) of the Act. Therefore, in analyzing the validity of impugned notices issued in July to August under section 148, only thing that which needs to be seen is, are the said notices valid under amended provisions or not? That's the submission.
So, Prakash, only one, just an incidental query I had. Now, the judgments of the high courts striking down the explanation to the notifications were in question before Ashish Agarwal, right? They were in question before this court in Ashish Agarwal. Now, are you also submitting that the judgment in Ashish Agarwal actually upholds that part of the judgments of the high courts which strike down the explanation to the two notifications? Is that your submission?
Yes, sir, because they expressly say we uphold the judgment of the High Court, and they also say, can I request your lordship now to go to Ashish Agarwal only for 1 or 2 paragraphs? Please go to Ashish Agarwal, which my learned friend has put in his paper book number 1.
Page?
Sir, it starts on page 1.
And we were in fact seeing that chart when Mr. Himani was arguing, that chart at page 11, 12.
Now, please see this Honorable Court expressly says on page 30, para 6.7, after para 7.
Page 13.
30, para 7. Thus, the new provisions, my lords captured.
Yes.
New provisions substituted by the Finance Act 21 being remedial and benevolent in nature and substituted with a specific aim and object to protect the rights and interests of SSC as well, same being in public interest, the respective high courts have rightly held that the benefit of new provision shall be made available even in respect of proceeding relating to past assessment years, provided section 148 notice has been issued on or after 1st April 21. We are in complete agreement with the view taken by various high courts in holding so. Sir, the Honorable Court is more specific.
Striking down of the explanation is upheld by our court.
Yes, sir. Please say, but please say para 8.
Most of them we accept except for their conclusion, which they want to, my lord. That's the only point. How do we use the order ultimately?
So please see page 31, para 8.
Yes.
Last about 8 lines. In our view, the same, that is 148, ought not to have been issued under the unamended Act and ought to have been issued under the substituted provision of section 147 to 151. If explanation is valid, then obviously it was validly issued under the unamended provision. Please see express finding.
So, really speaking, what our court did was, instead of treating these as notices under 148, they are now treated as notices under 148AB.
Correct.
Once they are treated as notices under 148AB, they cease to be notices under 148A. Under 148. So, after the 148AB process is undergone, a fresh notice will have to be issued under 148, and that whether it is within limitation will have to be decided on the date of that 148 notice.
That's precisely my submission. So please see, this Honorable Court has expressly hailed so. Kindly see, this is, please go to page 32, last 2 lines.
32, last 2 lines. Okay,
therefore,
to modify.
We modify judgments and orders passed by the respective high courts as under 1. Respective impugned notice compute section 148 notices issued to the respective SSs shall be deemed to have been issued under section 148A of the Act as substituted by the Finance Act 21 and treated to be show cause notices in terms of section 148A small b. Respective AO shall within 30 days from today provide to the SSs information and material relied upon by the revenue so that the SSA can reply to the notices within 2 weeks thereafter. I'll skip clause 2, which is not material. Now please go to clause 3 and 4. AO shall thereafter pass an order in terms of section 148A small d after following the due procedure as required under section 148A small b in respect of each of the concerned SSE. And all defenses are kept open, are available under section 149 and or which will be available under the Finance Act 21 and in law.
Did was it dispensed with the inquiry before issuing the
I'm
notice
obliged.
148AB.
Yes, sir. This is again read
notices as notices under 148AB. It dispensed with the inquiry under clause A because they were now conscious of the fact that well these notices had to be saved, treating them as notices under 148AB.
And sir, therefore, Honorable Supreme, your Lordships hold 148AD will logically be followed by 148 wherever revenue wants to reopen. So what is in challenge is the 148 notices issued now, somewhere in July, August 22. What has TOLA to do with this? Whole chapter of TOLA already stands closed and concluded in the first round of litigation. Now, even when your Lordships give this judgment, it did not require rocket science to know that 13, 14 and 14, 15 by now have become time barred. Surely this honorable court could have been requested
They didn't consider it. Superka, just read para 10 also.
Yes, sir. In view of the above and for the reasons stated above, the present appeals are allowed in part. The impugned common judgments and orders passed by the High Court of Judicature at Allahabad in so and other allied tax appeals and petitions are hereby modified and substituted as under 1. Impugned section 148 notices issued to the respective SSs which were issued under unamended section 148 of the Act, which were the subject matter of writ petitions before the various respective high courts, shall be deemed to have been issued under section 148A of the Act as substituted by Finance Act 21 and construed or treated as show cause notice in terms of section 148AB. AO shall within 30 days from today provide to the respective SSCs information and material relied upon by the revenue so that SSC can reply to the show cause notices within 2 weeks thereafter.
So really speaking, if the notices which are issued post Ashish Agarwal under 148, the fresh notices.
All 90,000 will go.
Sorry?
All 90,000 will go.
No.
Yes, no, statistics.
Sir, let me answer.
No, it's my friends are wrong. I checked it.
Which are beyond 6 years. 13, 14.
Yeah, 6 years. See, Lordship, I will just support 1 minute, Mr. Vijay Jain. I have a responsibility. All 90,000, I checked it up. I make a statement. Please, Mr. Jain, don't. 90,000 notices will go. Why? Because the two periods are 13, 14, 14, 15 for 6 years, 16, 17, 17, 18 for 4 years. But we always issue notices only at the time bar stage. So the entire 90,000 notices will become fruitless. Let my friends not make any statement. They don't have statistics. I have statistics to make the statement.
Let me indicate. Sir, let me answer. Mr. Jain.
Mr. Soparkar is in charge. So yes, Mr. Soparkar.
Sir, 13, 14, 14, 15 will go.
For 6 years. And
15, 16.
For 4 years.
One second.
My learned friend agrees 13, 14 and 14, 15 will go by my argument.
I'm agreeing on argument. Point.
He would have agreed with you.
Not conceding, by my argument.
Now, what do we do? He's swung to this side. One distinguished counsel he's dropped out of your ranks. Huh?
Sir, so far as 15, 16, 16, 17,
13, 14 and 14, 15
will necessarily go.
Under 6 years. Under 6 years.
Yes, under 6 years. Because in no case under the old law, you could extend the period of limitation beyond 6 years.
Right. Now, what about 15, 16?
15, 16, we are ourselves conceding wherever it's required. This not 4 year.
We're just asking Mr. Soparkar. Let's have a logical.
I'll ask the court 15, 16, 4-year period we can't invoke because it has become 3. Therefore, I put it in my note. 15, 16 won't survive. 6-year period will survive. So 4-year period will not survive. We have said that.
Yes, Mr. Soparkar. What do you say?
If the is accepting 13, 14, 14, 15 will go, then obviously I have succeeded. I don't, but I'm sure my learned friend is putting caveats. So let me complete my argument in 10 minutes.
Yes. Yes.
Sir, now kindly see, go to page 37.
How many are
18% is 13, 14, 14, 15.
80%.
80%. No, I have all the empirical data. That's.
But Mr. Venkatraman, subject to hearing you, when Ashish Agarwal decided.
We'll answer Ashish Agarwal. We have no difficulty.
Everybody knew that this is going to be barred. What is the whole problem?
It's the whole problem. I will assist the court, with great respect.
We went on a wild goose chase.
Which is wrong. All my 30 friends who are here never appeared in Ashish Agarwal. They have no idea what happened. I appeared I'm a party to the proceedings.
For that matter, even we did not participate.
Correct.
By the record.
I have an answer to whatever time, let him close. I have an answer for Ashish Agarwal, and what they are reinventing is their own creation, not our creation. We'll assist the court effectively with this.
So, Lordship, I may make a statement. I was a part of the Ashish Agarwal consensus.
Right, but even if you were, we were not a part of it.
You were, Lordship, or not.
So, I mean, we can't go by recollection.
I know.
Go by recollection.
Sir, we go by the judgment.
At 1 o'clock, a member of the bar wanted us to substitute a date of an order, which we passed yesterday. I said, look, I don't trust my memory to correct a date of an order which we passed yesterday. Get the other side here. Because in the Supreme Court, you don't know. Some little change you make in an order, what wide ramifications has. The other side came here, he says, yes, there was a typographical error. Even if you had not corrected it, I would have considered it before the NCLT. So, I mean, even we wouldn't trust my memory.
I appreciate
the record.
Appreciate.
So, Ashish Agarwal is now what the record tells.
What is the record? All right.
Go away.
All right.
Yes.
Sir, therefore, please go back to para 10 where I was.
Yes.
Para 10, subpara 1. The impugned notice under section 148 notices issued to the respective SSD which were issued under unamended section 148 of the Act, which were subject matter of writ petition before the various respective high courts, shall be deemed to have been issued under section 148A of the Act as substituted by the Finance Act, construed or treated to be show cause notice in terms of section 148AB. AO shall, within 30 days from today, provide to the respective SSC information and material relied upon by the revenue so that the SSCs can reply to the show cause notices within 2 weeks thereafter. So clause 2 is inquiry, which is not necessary. Therefore, I go straight to clause 3. AO shall thereafter pass orders in terms of section 148AD in respect of each of the concerned SSCs. Thereafter, after following the procedure as required under section 148A, may issue notice under section 148 as substituted, and next all defenses are kept open. These notices are subject matter of challenge before your lordships.
So it's just fresh notices which we have to decide whether it's barred by limitation or
not necessarily.
Correct. And the case pleaded before the Honorable High Courts was...
We'll assist your lordship on that. In terms of...
Sir, therefore, two submissions are being canvassed before a lordships. Kindly go. If I can request a lordship to go, before a lordship goes back to the note. So this is under Article 142.
Now, Mr. Superkar, why don't you do this? Why don't you formulate your argument? Because then
Yes,
you get the crux of your argument.
Two submissions only. Sir, but kindly go to my note, it is there.
All right, let's go to your note, Mr. Superkar.
So page 4 bottom, decision, two submissions are being canvassed. Decision of Ashish Agarwal applies only to those notices which were challenged before different high courts. So this is a judgment under Article 142. Please see page 30. Expressly this Honorable Court notes. Page 30, paragraph which is in the second half, last about 8 lines. We have proposed to pass the orders, aforesaid order in exercise of our powers under Article 142 of the Constitution of India. The page 30, sorry, I'm sorry, my mistake, sir. PDF page 35.
Therefore, we have proposed to pass. With a view
Under
to
Article 142. My lords, the Constitution Bench have taken a view 2020.
only judgments and orders which shall be made applicable in respect of the similar judgments and orders. Yes.
Now, there are two possibilities. One, it will apply to those SLPs, litigants of those SLPs which were before the Honorable Apex Court. Another possible interpretation is wherever the litigant was in some or other forum, it will apply.
Right.
Or the third interpretation is it will apply pan-India whether or not you have challenged in a writ petition.
But it's obvious that they say it will apply not only to the impugned judgments and orders passed by the High Court of Allahabad, but also be made applicable in respect of similar judgments
and orders.
Of various high courts.
So that I am considering the third situation.
Which clearly indicates that the proceedings would have been initiated by the date of the judgment in Ashish Agarwal.
I'm obliged. Mine is a case where I had not challenged first round of litigation before the High Court. First 148 notice I had not challenged before the Honorable High Court. So lordships have in a recent Constitution Bench judgment, High Court of Allahabad 2024 volume 6 SCC 267 have held that Article 142, howsoever wide it may be, it will only cover the parties before the court. Before a lordships in Ashish Agarwal, set of people were there. Lordships have also held it will apply to other judgments and orders before various high courts. Whether or not such a direction could have been given, it is given. But it can certainly not apply to people who were not there before any court. That's my first submission.
So those notices which are not governed by Ashish Agarwal, in other words, they will not stand converted into notices under 148 AB.
I'm obliged. And even then what they did was, they again issued 148.
Yeah, Mr. Venkatraman, but would that not be against the spirit of the judgment that you'll have different...
Our court has said, whenever you read, I've shown judgments. Whenever you read 142, you should first read 141 and then apply 142. I'll show judgments to this effect. We can't overlook 141. 142 cannot truncate 141.
Okay.
I'll show judgments.
This is not, sir, this cannot be under 141 because the Honorable Supreme Court, the lordships took a view, we confirm the judgment of every high court. Sir, once the law declared by every high court is confirmed, unless my lords exercise powers under Article 142, this direction could not have been given. So my first notice is kept hanging, and now second notice under 148 is issued, which is impermissible in law. And I've given judgment little later. And the second proposition, sir, page 5 bottom, sir.
So in other words, these notices which were issued between 1/4 and 30/6/2021.
Yes, sir.
The old 148.
Yes, sir.
Mistakenly would still have to be treated as under old 148 according to you, and they have to be ex specie quashed because that old 148 really didn't apply at all.
No, sir. What happens is they did not thereafter pursue with that notice, and they, on the strength of Ashish Agarwal, issued notice under section 148A, B, in the sense they gave information and passed order under 148AD. But then there is no 148AB in their case. Sir, if 148 in those cases does not get converted into 148A small b, because Ashish Agarwal does not apply, you don't jump to 148AD. Sir, I hope I'm clear.
Yes, sir.
Those who were not before any court, if I'm right, if Ashish Agarwal does not apply, then 148 notices remain.
That's what he's saying.
148 notices are kept pending. Revenue says we are now going to treat it as 148AB, which is not permissible. We will straight away pass order under 148AD and go for 148. So again, 148 notices are issued. Sir, your lordship,
that if Ashish Agarwal doesn't apply to these notices, then the original notices under 148 survive, subject to check.
But they would fail. Ultimately, they'd have been wrongly issued.
But they've been wrongly issued.
Because they'd be carried on appeal.
They can make the assessment and then can go and appeal and in the normal.
By now it has become time bound.
And therefore the new proceedings are fresh proceedings.
Entirely.
And if they're fresh proceedings, then the law as it stands on that day applies. There is no question of TOLA, etc. applying.
And these 148 notices were issued between 1/4 and 30th.
All notices, so lordship, 13, 14, 14, 15,
In fact,
16, 17 and 17, 18 are before your lordship 1/4/2021 to 30th June 2021. But 15, 16 are before 31st March 2021.
And in fact, my lords, in those cases, my lords, they've issued a fresh 148AB invoking the time limit of 3 years versus 10 years, invoking 10 years, and then taking sanction of the lower authority.
This is wrong.
The category where the assessment year is 13-14, but the notice has been issued on 6th May 2020. So prior to 31st March 20 or 1st April 2021. So I am not in this category, my lords, which has been dealt with by the court in Ashish Agarwal as well as in Rajiv Bansal. It's clearly, I can show you from the judgment, my lords, when I'll address, my lords. I'll just need 5 minutes.
For cases issued prior to, please send your writ petition. If your case is prior to 31/3/2020, there is no problem at all. Why should she be here? Please give us the writ petition. We don't have to be heard. No, please send it to him. That if it is,
I'm going to send it to
Venkatam.
Because
And I've been, the reply came that please argue the matter. I've already sent it.
We'll check it up. Okay. I'm not aware of both.
So let me continue. Please go to page 5, para 2.
Under 151.
Mr. Venkatraman.
I'll check that.
Well, to be honest, I believe my first point was that the SLP should be dismissed because there was admittedly no sanction under 151 taken. 151.
No, that's factual. We'll take it. If whether she should be de-tagged or not, we'll take it.
Overnight, please have it exactly.
Yeah. Whether she should be de-tagged or not.
I'll
The writ petition, sir.
The second submission of mine is, sir, please go to page 5, para 2. These notices are time barred. They are time barred because I accept time is extended up to 30th of June 21.
Just read that.
Sir, please see page 5. 2. Notice issued under section 148 in July 22 is time barred under proviso to subsection 1 of section 149. Note, order under section 148 AD is passed on 29th July 22, rejecting objection of the petitioner. Notice under section 148 is issued thereafter on 29th July 22. Now what follows is material. Key to find out applicable law is the law applicable on the date of issuance of notice under section 148. So Delhi High Court has taken a, would your lordship like to check up that observation? Sir, in the earlier round, it is, the view was taken, lordships have not interfered, that the day on which notice is issued, we must look at the law on that day, which in the present cases are issued in July, August 22. old notices under section 148 having been substituted by Ashish Agarwal are no longer notice under section 148. Therefore, they cannot be seen to test if the notice is issued in time or not. Notice is time barred under proviso to subsection 1 of section 149 beyond 6 years. I accept time is extended up to June 21. It is submitted that for the above two assessment years, notices under section 148 issued in July, August 22 are time barred because the same ought to have been issued on or before March 21 or at best June 21. Sir, then Roman 3 I point out, old section 149 gets substituted by new provision without any saving clause. So we now must look at the new provision. New provision says if you cannot issue notice under the old law by now, you cannot issue notice under the new law. And therefore, my submission 5, 6, 7, 8 is essentially this, that these notices which are issued after 30th June 21 are time barred. I don't need to go anywhere except this aspect for the purpose of time bar.
Yes.
Sir, now the revenue sought to protect this, please see the position that they had taken before the high courts by virtue of a board circular. I know my learned friend has given up, but what is the reason?
Relation back, my lord. I'm not going on relation back. I've not argued it, and let them not labor and take the time of the court.
Sir, okay, if it does not go back, then by which process of law notice is issued in July, August 22 be deemed to be issued before 30th of June 21? More so when 148 AD is issued in July 22. Sir, 148 notice can never be before section 148 AD order. In every case, 148 AD order is somewhere in June, July 22.
Yes.
Sir, 148 notice can never precede 148 AD order. Post Ashish Agarwal 148 AD, because Ashish Agarwal is of May 22, note substitution, etc. Fresh notice somewhere in June, July 22, fresh orders under section 148 AD, followed by section 148. Every notice is of June, July 22. How could 148 notice be there before 148 AD? It is not possible. If 148 AD does not travel back or remains in June, July 22, even 148 remains in June, July 22. By which process of law June 21 gets further extended. TOLA extended up to 30th of June 21. Thereafter, there is no extension. Sir,
yes.
Now, please look at the, I'll now finish in 5 minutes. Please look at the case of my learned friend. Kindly go to page 436 of paper book 2, PDF page 50. Brief note number 3. Within that, please go to page 437, para 5.
Yes.
Para 5. TOLA Act covers period from 31st March 20 to 31st March 21. Notification date to 31st March 21 extends TOLA Act to 30th April 21. Further notification date 27th April 1 extend to 30th June 21. Notification date 31st March 21 was issued when the old regime was in existence. Notification date 27th April 21 was issued. New regime took over. The following things are therefore critical. A, neither old section 149 nor new section 140 excludes applicability of TOLA. Sir, in new section 149, the question of TOLA will not be there. Question is not excludes applicability. First of all, it has to be shown it is applicable. On the contrary, section 3(1) of TOLA through a non-obstant clause extends applicability of TOLA both to old and new section 149 and 151. amendment carried out on 1st April 20 on the income tax with the specified act substitutes old law travel. Now, kindly see, travels back in time. How does it travel back in time?
Extent I admit. Lord, please take that out. I am sticking to my. It is enough if I argue that the relaxed provision will apply. I am not arguing
Sir, but I'm reading, sir, I was reading your notes, sir.
Your Lordship has also sir. Even in my submission 3 days back, the Lordship Chief Justice noted it. I said that I'm not insisting on traveling back. Very clear. I will not go by that.
Let's go to the next. Let's go to the next threefold test. Para 7. As to whether or not a notice issued under 1st April 21 and 30th June 21 is barred by limitation by virtue of limitation prescribed in the first provision section 140 and 1B can be determined by adopting a three-pronged test. Sir, these notices are already held to be invalid. Substituted. Sir, these are notices which are subject matter of challenge in the first round of litigation.
Saved. It is saved.
April 21 to June 21 are the notices which were issued under the old law, which were subject matter of challenge before various high courts. Various high courts quashed them. This honorable court did not keep notices alive. They have been substituted to be so code under 148A small b. Where is the question of testing this? With great respect, testing this would be putting a wrong question, which will necessarily take us to wrong answer. The correct question is whether the notice is issued post June 22 would still be within the period of limitation. Therefore, my learned friend's argument that these notices are valid because of, and kindly see even there my learned friend is wrong. He says first step is to identify assessment year for which reassessment pertains to. It must begin on or before April 21. I agree. Second step is to identify when the period of limitation expired under old 140 and 1B prior to substitution on 1st April 21. Agreed. The third step will be subject to passing the second step. If the limitations indeed survived under the second step, then the third step, notice for reassessment can be issued by following new regime prescribed under from 1st April 21. From where does it follow? So with great respect, we are, in my submission, the whole question of finding out notices from April 21 to June 21 is just not there before your lordships. For the very simple reason, all those notices which are subject matter of challenge in the first round have already been substituted by making them 148A small b show cause. Therefore, this argument must fail. Now, let me take your lordship 3 more minutes. My learned friend has been saying Delhi High Court judgment is the only judgment which correctly decides the issue. Please go to Delhi High Court. So Delhi High Court judgment, my lords would find in my learned friend's compilation.
Make your commission. Now we are deciding it as a matter of first impression. You need to go to any high court.
No, just give me 1 minute, sir. Yes. Honorable Delhi High Court says once 148A-B followed by 148A-D followed by 148 is issued, it will relate back to the original date. With great respect, it will not relate back. And sir, Mr. Pardiwala has already given, therefore I am not giving. Please look at 2024 finance bill also. Now they have made 2 separate limitation period for 148 capital A small b and another one for 148. The law as it stood or as it stands for the relevant period says limitation is only relevant for issuance of final notice under section 148. And therefore, whether 148A small b was within time or beyond time would not really make any difference. I'm immensely obliged, sir.
Thank you, Mr. Pagar.
May just clarify, Lordship, one point. 15, 16, 16, 17, 17, Tola will applicable is pure arithmetic. Pure, 1 minute only, pure arithmetic. In the sense, 15, 16, 6 year is 22, 16, 17, 23, and 24. My friends, in a table which has been shared in the first written submission, if your Lordship can just open that table, 4 years period he is assuming for 15, 16 to bring in 20. 16, 17 bringing 2021. Now, 4-year period is applicable under the old law only when income escaping assessment is less than 1 lakh rupees.
None of the case before your lordship and my friend has agreed is of less than 1 lakh rupee. So limitation applicable in respect of all cases before your lordship 15, 16, 16, 17, 17, 18 is of 6 years. There is absolutely not a single case of 4 years. Just give me, no, you're wrong statement. Not the threshold. My friend is speaking law wrongly. For 4 years, the threshold can be 10,000 crores also. For invoking escapement of assessment, the threshold is escapement plus 1 lakh. My friend can't say less than 1 lakh for you can't take me. Absolutely, it's a wrong statement in law.
May I?
Again, one minute.
That is his submission, not I'll address this.
Let's not go about roundabout. I make a statement with a responsibility. But this 90,000 show cause notices is in 2 buckets. 13, 14, 14, 15, invoking 6, extended by 8. 15, 16, 17, 17, 18, 4 years extended by 6. These are the 4, 1 minute, Mr. Sukrit. These are the only 4 years in which this 90,000 notices fall. 15, 16, wherever we have attempted to issue invoking 4 will fall flat because 4 has become 3 by default. So 15, 16 and 3. But 15, 16, 16, 17, 17, 18, 6 years, we don't need TOLA at all. The general period of limitation extends to 22, 23 and 24. Why should we be bothered about TOLA? We don't need TOLA at all. We don't have to bank on TOLA to argue these cases. Absolutely a wrong statement. That's why I'm interjecting it.
Before we
please make it clear, our threshold is 4 to 6 and 6 to 8. So whatever you decide for 13, 14, 14, 15 will apply for 16.
With great respect, it will not apply. Your lordship may only see the law for a moment because this I'll just take about 5 minutes.
All right. Yes, Mr.
Yes,
Yes, Surit. What do you have to say?
I'll come to this question of 4 and 6 years shortly. Before that, my lord, your lordships have already crystallized the basic question that arises in the case, which is broadly whether notices can be issued under the newly amended provisions of law which have come into force with effect from 1/4/2021 by reading the law in such a manner that even those notices which would be barred under section 149 as it stood prior to 1/4/2021 can be relaxed by virtue of the applications of the TOLA law. My lords, with great respect, my lords, the bare provisions as used under section 149 as amended, and the first proviso of section 149 as amended with effect from 1/4/2021, and it's been argued previously that Parliament's intention is very clear, that Parliament was quite conscious in its choice of words. The words that it used were, if a notice could not have been issued under the terms of this provision as it stood prior to 1/4/2021. Now, my lords, it's quite common where Parliament uses the words, if a notice could not have been issued under the law as prevailing prior to 1/4/2021. It did not pointedly use the words under the law as prevailing prior to 1/4/2021, but rather used the words under the terms of this section as it stood prior to 1/4/2021, which is the newly incorporated section 149. Now, if your lordships were to only see the TOLA notifications for a moment, this is only to reinforce what Mr. Hemani has argued. If your lordships would kindly take page 410 of the Revenue's paper book. This is the first of the notifications, 31st March 2021. At the bottom of 410, my lord, Clause A, which says where the specified act is the Income Tax Act, hereinafter referred to as the Income Tax Act, and the completion of any action referred to in Clause A of subsection 1 of section 3 of the Act relates to passing of an order under subsection 13 of 144C or issuance of a notice under 148 as per time limit specified in 149 or sanction under 151. 31st day of March 2021 shall be the end date of period during which the time limit specified in or prescribed or notified under the Income Tax Act falls for the completion of such action, and 30th day of April shall be the end date to which the time limit for completion of such action shall stand extended. Now, they clearly, my lord, here, as the explanation as well makes clear, referring to notices that are issued under the old Act, under section 148 of the old Act. Now, the second notification, which is at page 413, which is dated 27/4/2021. What it does is it effectively relaxes timelines that were relaxed under the 31st of March notification. So these are once again timelines under the old Act. So in effect, what these two notifications are doing, and especially the second notification, is that it is relaxing a timeline under a dead law.
Yes.
Therefore, at best, my lord, this notification is entirely meaningless, and at its worst, it's ultra vires. Because the law with effect from 1421 is the amended provisions of sections 147 to 151. Now, if they're extending timelines under a law that no longer exists in the statute books, and my learned friend has filed case law to suggest that the effect of a substitution is that the old provisions are effaced from the statute book. So if the provisions of section 149 as it stood prior to 1/4/2021 stood effaced from the statute books, this notification under 27/4/2021 cannot extend a timeline under that. Now, there's no quarrel with the fact that specified act under TOLA will mean the Income Tax Act and will also refer to the Income Tax Act as amended. But these notifications do not extend timelines under the amended act. Therefore, my lord, in my respectful submission, this notification is entirely ocious and it's a dead letter. And even at its highest, it's entirely meaningless. My second submission, this is only to address the point on 4 years versus 6 years. I just would request your lordship, my lord, to kindly take section 147 of the Act as it stood prior to the Finance Act 2021, which is at page 352 of my learned friend's paper book, of his compilation.
Yes.
As I'm not reading the entirety of the provision, I'll only take your lordship, my lord, to the proviso, the first proviso, which is the second paragraph at page 352. Provided that where an assessment under subsection 3 of section 143 or this section has been made for the relevant assessment year, no action shall be taken under this section after the expiry of 4 years from the end of the relevant assessment year, unless any income chargeable to tax has escaped assessment for such assessment year by reason of the failure on the part of the assessee to make a return under section 139 or in response to a notice issued under 142(1) or 148, or to disclose fully and truly all material facts necessary for his assessment for that assessment year. Now, your lordships know, my lord, prior to under the old regime, when notices were issued beyond 4 years, the revenue had to satisfy this additional requirement that flowed from the proviso in cases of prior scrutiny that the assessee ought to have failed to disclose material and true facts before the assessing officer during the course of the original scrutiny. Now, this is not a matter of a time limit that is specified under the Act. This is a jurisdictional precondition. This is not written into section 149, but rather written into section 147. Now, if my learned friend's argument is to be accepted, TOLA also extends this time limit specified under section 147.
Yes.
Under the proviso to section 147, which it never can be. Because TOLA was meant, even assuming for a moment, this my lords proceeds on an arguendo. Assuming for a moment that TOLA extends to the extension of limitation under the old Act, the provisions of section 147 were not amended by TOLA, and it certainly cannot relax these time limits specified under the proviso because that's not its intention. Its intention is to relax timelines specified in section 149.
Yes.
Now, if your lordships were to kindly come to section 149 at page 355, these are the time limits. No notice under section 148 shall be issued for the relevant assessment year if 4 years have elapsed from the end of the relevant assessment year, unless the case falls under clause B or clause C. B, if 4 years, but not more than 6 years have elapsed from the end of the relevant assessment year, unless the income chargeable to tax which has escaped assessment amounts to or is likely to amount to 1 lakh rupees or more. Now, therefore, my lords, the category of cases that fall between 4 and 6 years is only with respect to this quantum. They can, under no circumstances, relax the time limit specified under the proviso to 147, which is a jurisdictional precondition. It's not a time limit, really. It's a jurisdictional precondition, which the moment those 4 years have lapsed, that cannot be relaxed by TOLA. It could have only been relaxed by an amendment to the Act, which was never carried out. And finally, my lord, only have one further point to make, and this arises out of what your lordships put to Mr. Hemani. Because Mr. Hemani was arguing, my lord, that there are 6 critical changes that the new regime brings about. And therefore, your lordships were also of the view that perhaps your lordships might also have to observe as to how the new regime would have to play out. My lords, my only respectful submission there is that there are certain other concepts which we've not touched upon. For example, my lord, the idea of change of opinion, which was read into the old provisions of under section 147 by virtue of interpretation for the reason, for instance, your lordships would be aware of the Delhi High Court full bench judgment in Kelvinator, which was affirmed by the Supreme Court, where change of opinion was written into section 147 because the court held that if change of opinion doesn't apply, then section 147 itself would be open to challenge by virtue of it leading to arbitrary powers in the hands of the assessing officer. And therefore, it's an inbuilt test in 147. Now, the question is whether it remains an inbuilt test under the new law. We've not essentially argued on that because those are things which would come up in individual cases. Now, the revenues argument would be that by virtue of this amendment, all of these concepts have been rendered in nullity and that it no longer applies, and that all that is required is that income escaping assessment, that there is some information which suggests that income has escaped assessment. But in my respectful submission, even under that test, the idea of a change of opinion will have to be written into it, because otherwise, my lords, it leads to arbitrary powers once again in the hands of the revenue. Great.
Just I have shared this gradient folder.
Just to substitute what my learned friend has stated.
This is small note I've shared here.
Yes, yes, Mr.
Well, just to add to what my learned friend just stated as far as review.
The issue which I just wanted to clarify, your lordship, was period of 4 year and 6 year, which is pure arithmetic workout. 15, 16, 16, 17, 17, 18, 6 year out, 2021 doesn't comment. My friend's argument is that 4 years period is to be taken into consideration under the old law. First, we go under the old law, unamended law. If your lordship will see 1491, what the old law says, volume 2 of my friends. Sorry, volume 1. Page 355. It's a pure arithmetic, lordship. Lordship, take a case of assessment year 16-17. Income escaping assessment is 1,10,000 rupees. Will the revenue be permitted to reopen this assessment on, say, 10th April 2021? Answer will be yes, your lordship. Because period of not more than 6 years have elapsed. 4 years is not relevant. If yes, income escaping assessment is 99,000 rupees, then revenue will be not permitted to reopen the assessment as on 31st March 2021, after 31st March 2021. So in case income exceed rupees 1 lakh, either in assessment year 15-16, 16-17 or 17-18, TOLA is not at all applicable. TOLA says when there is any limitation is coming to your heart, there is no limitation coming in. 15, 16.
May I just take 5 minutes, my lords? May I just take 5 minutes?
In addition
My lords, may I start?
Yes, who would like to argue, Mr. Manish Shah or Mr.
My lords, I have handed over a report, my lords.
1.72. In fact, In fact, I'm going to add only two things.
Mr. R.K. Patel, your Lordship. Mr. R.K.
Yeah, Mr. Manish Shah, then Mr. R.K. Patel and Dr. Shivram there.
I'm not going to take more than 5 minutes because I'm sitting here with a strainer. In fact, quite a few things which I've stated in my written note, I'll be omitting because they're already argued. In fact, it is very extensively argued by my learned senior, Mr. Suparkar, that Ashish Agarwal takes care of most of the things. It does two things. It says, as a one-time remedy, we convert it into a show cause notice. And then the entire procedure and all the defenses which are available under 149 would be available. So I'm not going to argue once again on that. Very clearly, all the pages have been shown. In fact, Ashish Agarwal puts an end to the debate as to what TOLA does. My lords, along with that, Mr. Hemani, my friend, also touched upon the object. Now, that is where I would request my lords to see a few pages of Ashish Agarwal which also touches upon the object, and that is the reason it had come to that conclusion. May I draw my lords' attention to that relevant pages? My lords may kindly go to pages 27.
What does it say? You can just, without reading it, you can tell us what it says.
It lays down three objects why the Finance Act was brought and 147 was substituted. It says simplifying the tax administration. My lords did see as to how it simplifies. It simplifies for the reason that previously 148 notice was required to be given and then justify that notice. In this administration, 147, the new one, you have to give a show cause notice under B. The entire filterization as far as whether that information is correct or not, as an objection is to be taken in, that objections have to be dealt with, and then a 148 notice is to be given. That is the simplification of tax administration. Second object was ease of compliance. That ease of compliance has been brought in also for the reason that that 6 years time frame which is there has been kept, and that is the reason ease of compliance. And now comes to the most important aspect. The entire argument that these 90,000 notices would fall, the legislature was very well aware about it. In fact, it added a very important aspect as the object: reduce litigation. What the department is wanting to do is add to the litigation, though the statute does not permit it. The legislature was very much aware about it. In fact, my lords will find that on page 27, paragraph 6.1 of Ashish. So this object was very much taken into consideration. Second aspect. Later on in 149, in the year 22, an amendment was brought about, and which was a retrospective amendment. That is my third submission. That even at that time, the Parliament in its wisdom did not think it proper to bring in this very clarification if called upon to. And that is the reason it has stuck on to what was given to us in the form of the new 147. And fourth, the time frame of 6 years has not changed. What has happened is it was a mere extension and it was not an alteration. That has also been extensively argued. So we'll have to keep in mind the object. The object also overall was to reduce litigation, and they have been continuously exercising on that behalf, that we want to reduce litigation. So this is because otherwise extensively it has been argued.
Thank you, Mr. White. Thank you, Mr. Shah. Mr. Patel.
Mr. R.K. Patel. My lords, in item 1.72, SLP 19316 of 23, I have find specific 8 points, my lords, if it is readily available, or I will narrate, my lords.
Yes.
Please, my lords. My lord, first point is that there is a structural change from 1421. And this aspect is noted by Ashish Agarwal in para 6 of the judgment.
Yes.
My lords, what Honorable this court has stated is that there is a radical and reformative change in this scheme.
Right.
So the old scheme gets eradicated and an entirely new, structurally new scheme comes into existence.
Yes. What is the next point?
Next point is, my lord, TOLA was merely enacted to complete the ongoing proceedings as on 33/20, my lords. Third point is, my lord, there is no abeyance or moratorium on the operation and implementation of the new scheme from 1/4/21, which may please be noted. And my lord, fourth point, it is admitted fact that on 36/21, operation of TOLA ceases. Thereafter, the next finance bill and the next Finance Act 22, effective 1/4/22, my lord, it enlarges the scope and ambit of the provision of reopening by adding more in explanation 1 to section 148 by deleting the word flagged information. Flagged was deleted and all types of information were included. Not only that, in 149 small b, it enlarged the scope by including several expenditure, etc. But what is material is, my lord, so far as 149 proviso is concerned, the language remains intact. No notice shall be issued if it could not have been issued at any time. That phrase also remains intact if it could not have been issued in the prior period. That may please be noted, my lord. Thereafter, my lords, 148 specifically relates to 149 specifically relates to 148 only. No notice under 148 shall be issued. It does not refer to 148 capital A. Procedural aspect is disassociated from the limitation. That may please be noted. So therefore, on facts of each of the case, the fresh notice post Ashish Agarwal in July-August 22 is the only surviving and enforceable notice under 148. Because of Ashish Agarwal, the original notice under 148 goes into oblivion, my lord, by deeming fiction created by this honorable court. Therefore, my lord, respectful submission is touchstone Delhi High Court stating that the original notice gets revived. That lordship may kindly have a review. That may not be a correct proposition of law.
Thank you. Thank you.
Lordship, I'm very
Thank you, Mr. Dr. Shivram?
Yes, Mr. Please, my lord. My lord, I will be addressing only for 2015-16, my lord. Limited point only, my lord. My lord, that we are given the small submission before your lordship, running into about 11 pages, my lord. I will not repeat any of the argument what learned friend has argued. And my lord, for the 15-16 is concerned, my friend Mr. Percy Padiwal argued in depth. And my lord, he read the judgment of the GM also. What that judgment will find your lordship in 335 to 338 in the paper book submitted by the revenue. I will not read the judgment. Learned friend already read it. Well, one point, my lord, I thought of referring, my lord. In our submission, my lord, we have referred the one of the notice issued by the revenue that will lordship will point page number 9, my lord. There, my lord, for the same assessment year, 15-16, the department issued the notice by the sanction by the PCIT. And whereas the case before lordship GM Financial various matters, that is by the additional commissioner. My lord, my whole limited submission, my lord, that there are maybe thousands of matters where the department issued properly by getting sanction from PCIT. And because some of the officers take different view, therefore they issued notice under deputy commissioner. If that is the view, my lord, the department taking contrary view in respect of the same type of SSCs in the same SS in the same ward or one different ward, that may be contrary they are arguing. For that, I limited only one judgment, my lord. Berger point may be referred. That is 12 SCC 42, paragraph number 12, where department cannot take contrary stand. That's all, my lord, as regard the 15 is concerned.
Now, anybody else? Mr. Rath, we've got a couple of lawyers online. Mr. Rath.
I am appearing in the 1.56. The present SLP is infructuous, my lord. Actually, in fact, my lord, kindly come to the page C of the synopsis.
Rendered infructuous.
It is infructuous.
1.56.
My lord.
Mr. Rath wala SLT, yeah? Mr. Rath, 1.56, right?
Please, Your Lordship. Pitabas Acharya.
Your father?
I am for the respondent, my lord. Respondent 1, my lord. Pitabas Acharya.
We agree with him that this.
This common ground, but especially petitioner being able to discuss this, especially petitioner accordingly dismissed.
1.6 for a very short point.
Then who else? Mr. Vora? Mr. Vora?
Yes, my lord. My lords, in 1.151, I have placed my written submission. Only one additional point I want to place. My lords, my proposition is that old and new provisions cannot coexist at the same period. Between the period 1/4/21 to 30th June 21, department can issue notice as per new law following new 148. At the same period of time, following old law also, they cannot have an option either to choose new law or to choose old law.
Thank you. Thank you,
That's all.
Mr. Balani.
Yes, my lords. My lords, my point is with regards to dealing with the third and fourth proviso to section 149, which deals with the exclusion of limitation period, which shall be argued by the other side, my lords. My lords, my point is the opportunity to respond to the show cause notice was provided only in May 2022. So if any exclusion has to be calculated, it has to be calculated from May 2022 and not before. This was the precise code. Please, my lords.
Thank you. Thank you, Mr. Balani.
Please,
Mr.
my
Malhotra?
My lords. May I submit, Your Lordship?
Yes, Mr. Malhotra.
May I submit?
Yes.
My argument is based on this factual position that in the view of legal background, if the fact of the case are looked into, it can be seen that notice under section 148 was issued for the assessment year 2013 to 14. Thus, notice under section 148 must satisfy the additional condition mentioned in first proviso to the section 149 of the amended act to be considered and valid notice. If we calculate 6 years from the end of the assessment year 2013-14, the last date of issue and notice under section 140.
Mr. Mehrotra, do you want to add anything to what Mr. Goetan said?
Well, I have one short point to add on to. Well, the relaxation law, section 3, did not permit an omnibus extension of limitation. Well, the respectful submission is it is a case-to-case extension. Inter alia, where only the department desired issuing a notice, could extension be invoked. So therefore, my lords, it will not ipso facto cause an amendment to section 149 on a holistic basis.
Thank you. Mr. Sinha?
Yes, my lordship. I have only one point to submit, my lordship. That is the first proviso of the section 149, my lordship. There is a one, this proviso talks about the erstwhile section 149 1B. So this is the legislation by incorporation, not by the legislation by reference here. There is a difference between the legislation by reference and legislation by incorporation, and I'm relying on the Girnar Traders, the Constitution bench judgment, my lordship, for this purpose here.
Mr. Shah, you wanted to, you had your hand up. Something else that you left out?
Very, very esteemed colleague did argue as far as change of opinion is concerned. I just want to add only one thing. The courts have stated that because of Kelvinator, the judge ratio was that wherever a power of review is to be looked into, it is to be specifically given in a statute. If it is not given in a statute, it can never be read into that statute. And that is the reason Kelvinator came about, and that is where in 147 the power of review cannot be given. That is one thing, and that is the reason the change of opinion is a judicial concept. It is not a concept which was there in 147, and it was read into 147.
I think we have heard everybody on the screen now. The last round of counsel who are here present.
Right.
Yes.
My lords, this is with respect to my lords have till now heard the point, my lords, that if TOLA does not apply.
Yes.
My lords, of course, if TOLA does not apply, the entire edifice of the department goes, my lords. my lords, we have alternative submissions with respect to 15-16, 16-17, my lords, which is where the question of obtaining sanction is concerned. And we are before my lords because the court below took the view that the sanction which was obtained was of the lower officer as opposed to that what is required under law of the higher officer, my lords. My lords, there are two submissions, my lords, and the first case, my lords, that I'll put before my lords is AY 16-17. I've just listed down my propositions, my lords. My lords, firstly, my lords, as I said, I'll just articulate the point as to 149 why does not provide a time limit of 4 years, my lords. My lords, we'll just see section 3 for a minute. It specifically says, TOLA section 3 uses the words where any time limit specified. The time limit specified under the Act is only under section 149. And the time limit specified under the Act under section 149 is that if your case falls below rupees 1 lakh, then the time limit is 4 years. If it goes beyond 4 lakhs, the time limit is more than 4 years, 6 years. Now, so far as 15, 16, 16, 17, 15, 16 and 16, 17 are concerned, the 4-year time limit does not apply at all because none of the cases before my lords are below 1 lakh. Therefore, the time limit on which the proceedings get barred is not 4 years, but it is 6 years. And therefore, for 15, 16, it would be 6 years, would be 22, whereas no question of TOLA applying. Insofar as 16, 17 is concerned, 6 years would be 23. Again, there is no question of TOLA applying. Now, that apart, my lords, the two other submissions that we have, my lords, is this. AY 16, 17, which is the first case before your, my lords, over here in the note that I've handed over, because that was a case where I had not challenged the proceedings in the first round, which Mr. Soparkar alluded to, and which is bucket 4 of what Mr. Pardiola argued. Well, what happens thereafter is that in May 2022, they issue a fresh 148 AB notice. So the old proceedings are given a go by 2. They issue a fresh 148 AB notice. They refer to the income exceeding in excess of 50 lakhs. The moment they refer to income exceeding in excess of 50 lakhs, they are relying on the time limit prescribed in section 149(1)(b), which is in excess of 3 years. As a result of which you require the approval of a higher authority, which is the principal chief commissioner. The High Court has struck it down on the footing that you obtained the approval of the principal commissioner, which is a lower authority. Mr. Sridharan had pointed out the decision of the Supreme Court in 1961, CIT versus Pratap Singh Bahadur, which said that sanction is absolutely necessary, my lords. 1961 SCR 760, page 1519 of Mr. Sridharan's compilation, my lords. That's the decision which holds that if the sanction is faulty, then the proceedings lose jurisdiction completely, my lords. My lords, now, in my case, my lords, as I said, if I have not challenged the first round, my lords, what happens is, my lords may come to para 3 of my note, my lords. My lords, so whether TOLA applies or not, in cases of sanction, my lords, the real question is, what is the impact of Ashish Agarwal? If Ashish Agarwal does not apply, the old 148, I'm reading 3A1, my lords. The old 148 is not challenged. Therefore, Ashish Agarwal does not save the old 148 because Ashish Agarwal only applies to cases where proceedings were pending either before the High Court or before the Supreme Court, my lords. In that situation, if I have not challenged the 148 in the original round, in view of Ashish Agarwal para 7, which holds that the decision of the High Courts holding that the 148 issued under old law is bad after 1421 applies and therefore the old notice goes. Alternatively, my lords, what happens is even if one were to assume that in view of Ashish Agarwal, that notice gets converted into a 148 AB notice. My lords, now, insofar as a 148 AB notice is concerned, the time limit starts as per the decision of the Supreme Court from the date when the notice was issued. It extends up to the passing of the order under 148 AD. Now, fourth and the fifth proviso, my lords will recollect, of section 149, they exclude from a computational of perspective of issuing the notice under 148, they exclude the time limit of show cause notice plus passing of the order, my lords. My lords, have that under 149, the fourth and the fifth proviso, they exclude the time limit which is given to the assessee to reply and the time limit to pass the order. Now, that is for the purposes of issue of notice under section 148. They do not exclude the time limit for the purposes of sanction under 151.
Yes.
The sanction under 151 is a factual determination because as on the date when the notice is issued, one has to see whether it is beyond 3 years or within 3 years. In my case, my lords, as I said at page 157 of the petition, my lords, they've invoked section 149(1)(b). If my lords will for a moment turn to...
Just to save his time, I'll help my friend. My lord, please give me those repetitions where originally it was 3 years, which became 6 years. and they survived on old sanction, please give me the list. Well, I'll take instructions tomorrow, and this is slightly different. Please, let's not waste time on that. If you have expanded it, you obviously have to take a permission from the different authority. Please give me those lists alone. 3 becoming 6, please give me, don't be academic. If you are arguing academically, I have no answer. If you have an underlying writ petition, where originally it was 3 years, which became 6 years, give me that.
16, 17, my lord, 16, 17.
No. Where they have changed the gear from 3 years to 6 years, show me that. I'll take instructions tomorrow, my lord. Those cases are separate.
I'm not, I can only show, my lords, the
He's
notice
arguing,
and the 148.
he's arguing you, then he's arguing backward.
No, it's not a question of arguing backward. No, if
Just have a look at what he has
Yes,
said.
yes.
If you want,
we'll come back tomorrow to us.
very well.
please give me this.
And in so far as, my lords, there is one more point. My lords will see, one of the arguments taken, my lords, will come back to TOLA, my lords. Just for a moment, my lords, will please see section 3 of TOLA. My lords, one of the arguments which was earlier made, that section 151 does not prescribe alignment. Section 151 is the section which requires obtaining of sanction. The argument made by Mr. Padiwala was that there is no time limit prescribed. That's not really a time limit, because when the officer actually goes to issue a notice, he'll have to see what is factually there, as in whether he is beyond 4 years or within 4 years, and therefore he has to determine which officer to go to. The argument of the revenue to that is, no, look, section 3 of the act says that the time limit for grant of sanction is also extended. So therefore, TOLA applies to even obtaining of sanction. The question therefore that arises, my lords, will just please see page, the new 151, page 361, new section 151, my lords. New section 151 prescribes the authority of the officer to exercise grant of sanction, namely whether the principal commissioner can grant sanction or the principal chief commissioner could grant sanction. He could exercise authority beyond 4 years. So if, my lords, his authority to grant sanction is capped as within 3 years or beyond 3 years.
Right.
Now, when does his authority and the limitation prescribed under his authority commence? Only when an application is made. So say, for example, my lords, in 1617, if the application is made as on 31st or 20th March 21, he would get 10 days to issue a sanction, to keep it within 4 years. Now it is that which gets extended.
Yes.
So if the sanction itself is made after 31st March 21, then there is no question of TOLA applying, because his sanction itself is invoked after 4 years. So my lords will read section 3 to mean, please see section 3, my lords, where any time limit has been specified or prescribed or notified under the specified act, which falls during the period 20th March 2020 to 31st December 2020, or such other date after the 31st December 2020, as the central government may by notification specify in this behalf, for completion or compliance of such action, completion of any proceeding or passing of any order or issuance of any notice, intimation or sanction or approval. So the grant of sanction, my lords, whether officer A, if my lords come back to section 151, the principal commissioner can grant sanction if the officer has approached him within 3 years.
Yes.
The principal chief commissioner has to grant sanction if he goes beyond 3 years.
Yes.
So what is relevant really in that case is to determine when did the assessing officer approach the principal commissioner. It's only thereafter that the time limit for that officer exercising sanction commences. Now, in all these cases, my lords, in fact, for AY 1617, the application to the officer for grant of sanction itself is made in 22. That is beyond 3 years.
Let me hear the other side on this.
Yes, right.
Thank you.
Great, deeply obliged.
Because I've just been told by the learned ASG that the matter that I have, Malad, it is part of this batch. So he feels that, Malad, my only request would be, Malad, nobody has argued prior to 1/4/2021. I fall in that limited category. The learned ASG feels that it is part of this batch. So Malad, hear me 2 minutes only, whenever.
May I please minutes? Malad, there is a shorter version of my synopsis, if Malad can have a look at that. There was a written in the synopsis, written submission by Kavita Jha, and there's a shorter version, Malad. After hearing to all my learned friends, I thought learned seniors. Submission is, it's a The shorter version, I thought, since I've already heard all my learned seniors, it's a shorter version. Malas, if Malas can see my...
What is give us the punch point, one
Yes,
punch point.
3-4 points I wanted to supplement. All other points have already been covered. Malas, law on the date of issuance of notice has to be seen. Malas have, in fact, have seen. Malas, I just wanted to rely on one judgment, which is very, very important. And in fact, Malas have seen Supreme Court, but C.B. Richards from Delhi High Court, which has been referred and relied by most of the courts. Malas, paragraph 3, 8, and 12, I just wanted to show paragraph 12, how the law of limitation has been dealt with. And they have referred to various Supreme Court judges. Malas can have a look at this. Paragraph 12 once.
Kavita, grab one copy for us.
Yes, sir. So the first point I wanted to, point, my lords, notice issued under section 148 has to be seen or has to be tested as per the law prevailing on that date, even if it relates to prior assessment years. My lords, paragraph 3, 8, and 12 are relevant, but I just want to show paragraph 12, my lords. Law of limitation does not create any right in favor of a person or define or create any cause of action, but simply prescribes that remedy can be exercised or availed of by or within the period stated and not thereafter. Subsequently, the right continues to exist but cannot be enforced. The liability to tax under the Act is created by the charging section read with the computation provisions. The assessment proceedings crystallizes the said liability so that it can be enforced and the tax, if short, paid or unpaid, can be collected. If this difference between the liability to tax and the procedure prescribed under the Act for computation of the liability, that is procedure of assessment, is kept in mind, there would be no difficulty in understanding and appreciating the fallacy of the error in the primary argument raised by the revenue. It is settled position that liability to tax as a levy is normally determined as per the statute as it exists on the first day of the assessment year. But this is not the issue or question in the present case. The issue or question in the present case relates to assessment years, that is initiation of reassessment proceedings, and whether the time limit or limitation for initiation of reassessment proceedings specified by the Finance Act 2001 is applicable. We are not determining or deciding the liability to tax, but have to adjudicate whether the reassessment notice is beyond the time period stipulated. This is a matter of a procedure, and that is the time period in which the assessment or reassessment proceedings can be initiated. Thus, the time period or limitation period prescribed on the date of issuance of notice will apply. In our opinion, the answer is clear and has to be an affirmative in favor of the SSC. So, my lords, they were also, in fact, analyzing the amendment which was brought in. Now, my lords, second point is the various amendments has been brought in section 149 from time to time. My lords, legislature was conscious of giving the effective date. My lords, we'll have a look at the annexure, which I pointed out with my synopsis. Have a look at this, my lords, which is page 5.
Yes.
Malas have page 5. Malas can see that these annexure which says, as and when the amendment was brought in section 149, Malas, the effective date of coming into force was given. If Malas can have this column, like for example, income tax 1961, Malas, when the period was amended, the effective date was 1/4/1962. Then Direct Tax Amendment Act 1987, Malas, this was effective date 1/4/1989. Then Finance Act 2001, Malas, when this was brought in, the effective date is 1st June 2001. And Finance Act 2012, when the amendment was made in section 149, Malas, the effective date was 1st July 2012. So, Malas, Finance Act 2012, the effective date was 1st July 2012. And Finance Act 2021, the effective date is 1st April 2021. So, Malas have to treat this date as sacrosanct. So, legislature was conscious that the 1/4/2021, the new Finance Act has already kicked in and the new provisions have to apply. So, this annexure is only for that purpose, Malas. I'm not reading the synopsis.
Thank you.
Now, Malas, there's one more point. In fact, I wanted to show. If Malas can have... Malas, and so for Finance Act page, in page 6 also, Malas. So for Finance Act 2021 is concerned, Malas, there are various sections which, as and when they wanted to make it effective, they have given dates. Malas, have a look at page 6 once. Malas, have?
Yes.
Like for example, section 194, the effective date is given, Malas, 1st April 2020. Like for example, 153B, the effective date is given. For example, Malas, 147 to 153A, there is a specific date given as per Section 2 Clause A of the Finance Act, Malas, which is 1st April 2021. Now, like 194 IB, Malas, effective date is 1st July 2021. The point which I'm trying to make is, Malas, Finance Act 2021, so far sections are concerned, they were conscious that as and when they wanted to give effect to a particular section after a particular date, they have given those dates. So for these reassessment proceedings are concerned, provisions are concerned, they were conscious and they have given an effective date as 1st April 2021, Malas. So this has to be treated as a sacrosanct date, Malas. And even there's just one more point, Malas. So for TOLA notification is concerned, there were 2 notifications which were issued by the CBDT even after 27th April 2021, which I have annexed as Annexure C, Malas, for extension of date. This is 25th June 2021. And there's another notification which was issued, which is 17 September 2021. So TOLA doesn't lose its effects after 27th April 2021. In fact, for relaxation of time and for completion of assessment, they had issued notice and that is there. So I just wanted to show those notifications which are Annexure C. And just for completeness, Mr. Mani has already referred to the budget speech. If Malas can also have a look at the memorandum, Malas, that's very important. Why was this brought in? If Malas can have a look at this. I'm being a little fast, Malas, but yes, I'll just two seconds. Memorandum, it starts at page Malas 137. The relevant is 187. It specifically mentions why was this amendment brought in, Malas. Malas, want me to read it?
No, we'll read it.
It is page 185, Malas. So memorandum is also equally important. And Malas, one question Malas specifically raised that so far those notifications, explanations are concerned, why was it struck? Malas, in MMK, Manmohan Kohli judgment, which is there at page 316 of Mr. Vaidyan's compilation, paragraph 99 is very crucial, Malas. They have struck down these explanation on the ground that this is ultra vires the Relaxation Act, Malas. So only that's question fell from Malas.
Mr. Kaushik, yes.
Lordships, I am trying to canvass a point which is not taken till now at all. The department has 3 pillars to stand. One is TOLA, second is the proviso, first proviso, and third is the Ashish Agarwal.
What is the point?
The point, reading TOLA itself, section 3.1. If my lordships can kindly please take section 3.1 of the TOLA. Lordships, TOLA itself, reading TOLA itself, TOLA will not be applicable as the case of the department is. Why? Sir, TOLA is only applicable. There are prerequisites for TOLA to be applicable. The prerequisites are provided under 3.1. If my lordships can just for a moment turn to TOLA for 3.1. 3.1 says there are 4 prerequisites. First, it says that there has to be a time limit. Time limit which is specified by a specified act. Second is that a time limit should be in a particular period which is specified by a notification or in the TOLA. Third is that within that time limit should be for issuance of such action.
And
which is it. Fourth is very important that if during such time, such action is not taken,
then it's
such time is not taken, then the word used is then.
Consider it. You got your submission.
No, Lordship, 2 minutes because this goes to.
What to do for we are stopping, because we have kept a special matter at what to do for Ms. Arora is waiting. So last 2 minutes.
Lordship, this goes to the root of the matter. The reason is this wise that, Lordship, why it was not, as argued, why it was not amended in section 149 itself. The reason is that under 140, the TOLA creates 2 categories. One category is where the notices have already been issued within that particular time period. That is 31st. And second is, and third, therefore, Lordship would see the word then is used. Therefore, TOLA is only applicable from 1st April 2001. It is not applicable. So the old act and the TOLA are not concurrent. They are consecutive. So only at the end of, and last point, Lordship, last point, in this view, if the intention of March notification is also seen, that the time limit was only extended or could only be extended if the explanation is there, which means that under the old law, only if old law is applicable, the time limit will be applicable. They also knew, and therefore the explanation was added, which has been struck down. and therefore the entire provision would fail.
Yes, Mr. Please, my lords, I am for 13, 14 and 14, 15, my lords. Now, my lords, for 13, 14, my lords has already been argued by Mr. Pardiwala. For 13, all these notices were given in July 22, my lords, and was argued by the learned ASG. These are the notices from April to June 21, my lords. For 13, 14, my lords, the period gets over 6 years on 31/3/2020, and for 14, 15, 31/3/2021, my lords. The point I am trying to make is 28th of March 2021, my lords, the Finance Act 21 came into being, and the amendment was brought in from 1/4/2001. And the amendment was again minus 6 years. So minus, if we take 13, 14, and 14, 15, minus 6 years gets over on 31/3/2020 and 31/3/2021. The only way, my lords, which they are trying to point out is because of TOLA. Now, TOLA was minus 29/9/2020 that TOLA was brought in, my lords. Even if we see TOLA, my lords, that also gives period till 31/3/2021. The extension which even the TOLA gets is by those two notifications. So the point I'm trying to make is even those two notifications are by virtue of delegated legislation, my lords. Those two notifications by page 410 and 413, my lords, are by virtue of section 3, my lords. So what I'm pointing out is the parliament was very well aware. They were very clear that that period has to be 6 years only, which gets over on 31/3/21. TOLA also, my lords, the main act is 31/3/2020 when the period gets over. It is only by those two notifications dated 31/3/2021 and 27/4/2021, which extend to 30th June. It is by those delegated legislation. So just for submission on that, my lords. The first submission is intention of legislature was very clear that the period of 6 years was there, my lords, which gets over on 31/3/2021 for both the assessment year. That's the first point. Second point is, my lords, notification issued is distinct from legislature, my lords. Even if we treat it as to be part of statute, the subordinate rule is not lost, my lords. Just two judgments, Constitution Bench AR 1961 SC 838, my lords, para 20, page 183 of my compilation, which we filed, my lords, on 3rd of April 2021, 2 SCC 209, my lords. My lords, the third submission is subordinate legislation can be questioned if it does not conform to a statute under which it is made or contrary. So in this case, my lords, it is not conforming to the main statute, which is the Income Tax Act, which is very well clear that the period gets over on 31/3/21 from 1/4/20. They are trying to get. Just one more submission, my lords. If majority high courts have taken a view, my lords have said at least in income tax matters, my lords normally lean towards that view. In this case, there are 5, 6 high courts, my lords.
But the explanations have been struck down by various high courts, confirmed by the Supreme Court. What is the effect of it being struck down? They're not in the statute. As a result, we have to see what is the time limit to issue notice under the old law if the explanations are not in the statute. Because the explanations are not in the statute book, the last day to issue notice under the old law is 31st March 21. If my lords go by the first proviso to section 149, even if TOLA applies with the explanation is being struck down, last day is 31st March. Second point, but when learned ASG argued about non-obstante clause, we have seen the TOLA and the notifications that it extends something which is expiring between 20th March 20 to 31st March 21. New Act applies from 1/4/21. But there is no conflict. There is a question of non-obstante applying and TOLA being made applicable to Finance Act 21. It extends something which is expiring on 31st March.
We'll have to wrap up now.
But last point, just one last point. Yes. But so far as my 15-16 is concerned, in my compilations, I am appearing in 1.1 matter. In my compilation, I have referred to 4 judgments of the High Court where the department itself has taken a view that it is beyond 4 years, and therefore they have taken sanction of the principal commissioner. And let's judgment in case of Ghanshyam Kavrani notes. I'll just hand over the judgment. We'll just see para 6 and 7 lordships have taken a view. Para 6 and para 7, my lords. Yes. Last page. We'll just come to the last para, my lords.
Yeah.
But in the last para in the middle, in the present case, the Additional Commissioner of Income Tax forwarded a proposal submitted by the AO to the Commissioner of Income Tax approval, which has been granted is not by Additional Commissioner of Income Tax, but by Commissioner of Income Tax. There is no statutory provision here under which a power to be exercised by an officer can be exercised by a superior officer. When a statute mandates the satisfaction of a particular functionary for the exercise of power, satisfaction must be of that authority. When a statute requires something to be done in a particular manner, it has to be done in that manner. In a similar situation, the Delhi High Court in case of HPL Siddhartha held that the powers which are conferred upon a particular authority have to be exercised by that authority, and the satisfaction which the statute mandates of a distinct authority cannot be substituted by satisfaction of another. We are in respectful agreement with the judgment of the Delhi High Court.
Well, just two short points. Malaj. One, that Malaj, this argument which is raised day in day after that there are 90,000 petitions and therefore Malaj should take a different view. But with great respect, there is no law which indicates that if there are more petitions, then don't be condoned. That's point number one. Point number two, Malaj, on the sanction, Malaj, under the new law, the sanction is by the PCIT and the Principal Chief Commissioner. And those sanctions come after the order under 148 AD, where whilst in the old regime, Malad saw, which Mr. Himani pointed out, the sanction was prior when the 148 notice is issued. And the objections and order is passed thereafter. So thereafter, if any sanction is to be granted after 1421, after the 148 AD order, it has to be by the new authority, not as per the old regime. Because he has the benefit of the AD order and the notice. So therefore, Malaj, it will be incongruous to argue that a sanction under the new regime after the 148 AD order should be as per the old 151. Because that's my list. In respect of 1516. Sorry, there's one matter, 1.114. Item 1.114, because we'd sent an email. So just see. I'll just mention and leave it.
Just two short submission, my lord.
With respect to 1516.
Just one short submission, my lord.
One submission. Just take time. I just feel the only to do this, whatever remains, give us a one-page note by tomorrow.
1516, our notices are before 1st of April 2021. They are 27th of March 21. The only issue is of sanction, Milots. In that, Milots, the only submission is that since the time period of 6 years has not elapsed, so they could not have used the benefit of toll Milots. But and second is, Milots, the reasons to believe which were provided are provided in November.
But just two short submission, Milots, if Milots permit.
Can I take it as not? I'll start the rejoinder tomorrow morning. I'll
may I just
their side is over.
Submission, Milots. Just
Lordship may declare it so. Your Lordship may declare their side is over. I don't want fresh new faces coming tomorrow morning.
4 o'clock, my lords. Just two short submission, my lords.
My lords. Modi Natural Limited.
Whatever you want to say, you say. I'm going to do it only tomorrow.
We'll do is we'll take up your matter first at 10:30 tomorrow morning, and then we'll take up Mr. Venkatraman and rejoinder. We'll hear you at 10:30 tomorrow morning.
My lords, very well, because my matter is listed before the High Court tomorrow.
Tell them that we are taking it up at 10:30 tomorrow morning.
Very well.
And then we'll hear Mr. Venkatraman.
Other side is formally closed, Mullah.
But just two short submission, my lords.
Give us all your submissions.
Exhaust interpretation what Modi Natural Limited lordships have this bench has held.
But the submissions may be taken as heard, my lord.